It's like, why are we not talking about this? Your family is fucked. Your children are fucked. Everyone's so beyond fucked. Like, you have nothing to gain by not talking about this. That's the part that pisses me off. The attorneys, the courts, it's like, dude, like, you have nothing to lose and everything to gain by talking about this. So I don't think of it as a me against them at all. I think of it as, bro, shake off the chains, man.
Right.
Like, you're just as fucked by this information that I'm trying to talk about as I am. And so when I say you're fucked this way or you're fucked that way, the definition of fucked is, yeah, you're wrong, but at the same time you're freed. So it's not like I'm trying to crush them, I'm angry at them or anything. In fact, if they would just stop being faggots for a second, they would benefit so much by the conversation.
That's where your post, and I'll read it. White privilege in America is so far beyond what any liberal could even hope to comprehend. Take the most bleeding heart liberal in the world screaming for equality, and they aren't even in the right galaxy. It's so far beyond that, it would melt their brains. Times it by tens of thousands, and maybe you'd get close. You're 100% on point with that.
Exactly. There's more to it than this. Obviously, the people who watch my stuff know this, but I like one-liners. I like shockers. I like Schwarzenegger one-liners. I'm starting to kind of get into that because it's kind of fun. It creates excitement. It creates interest. It creates a discussion. I don't say it.
Is that the whole point behind your like racism stuff too? Because when I read stuff like I just read, it's like, I kind of understand the marketing angle of the racism stuff, but clearly you're not racist or you wouldn't be putting this information out in the public.
Yeah, it's everything I do is in an effort to get discussions going.
First off, man, before we really dive in, how you been? Any updates that you want to share before I start down my list of questions and discussion points?
No, let's just hit record and roll.
All right, man. Well, my first discussion point is an update on the credit union. That's one of the topics that I feel like isn't...
I don't talk about it a lot because
Yeah.
it pisses me off, because what I hear when people ask me about it, not you, but everybody else, is I'm too lazy to fucking do anything about anything. Fuck you. When are you going to do this thing so I can be a fat, worthless, faggot piece of shit and sit on my ass and just swap fucking instruments? That's why it pisses me off. It's gluttonous and un-American, and that's why I get angry. And I've never really said that before, so I guess it's good to kind of...
Well, as the guy running the credit union, wouldn't you be able to have some discretion over the...
I think about it a lot. Every time I get asked about it, I think, God damn, how do I stop people like this from getting into the credit union? So it's one of those things that I will be figuring out. We have multiple teams. I'm not on top of all the teams, so I don't know everything they're doing. I don't know what's going on. I don't know even where they're at. I think most of them are at phase 2, which is the last phase. That's all I know. I don't know what's going on. In 3.0, I'm going to offer to the audience that I will work for the first 3 credit unions that get opened for free. So I'm hoping to light a fire under everyone's ass, and I'm going to go and show them exactly where on the credit union, the NCUA or whatever it is, I'm going to show everyone the exact link, the exact thing to fill out. I'm going to cover what phase 1, what phase 2 is, and then I'm going to show them on the NCUA website where all the information is in terms of how all of that works. And I'm just going to send 100,000 people in there, and the first 3 people to get it done, I will work for free, because I just have too many projects going on. I did try to open my own. I got through phase 1 partially, and then I wasn't able to get through phase 1, and then it's so vague what you have to do, and there's so many subjective aspects that are not well explained that it just makes me very angry. So I started getting very angry, and then I decided, you know what? I'm just going to back off from this. I have a lot of other projects going on, and there are already other people that are much, much farther along in this than I am. I'm just going to defer to them. And so that's kind of where that went. Does that mean I'm never going to open up my own from scratch? No. It probably means that we'll get 3 or so opened, and then I'll work with them, and then by then I'll have a lot of knowledge and understanding as to how to do it myself through others. And then at that point, we'll probably open our own with all of that knowledge at that point, because then I won't be so fucking angry about it. That's it. I don't really know what else to really say about that at this time. I'm not thrilled. There's a part of opening a credit union that absolutely terrifies me, because obviously all hell is going to break loose, and I'm just going to have all these gluttonous, un-American pieces of shit breaking through my windows like zombies. It's basically going to be like a zombie apocalypse, essentially. That's the way I look at it, right? So people wonder, like, why isn't Brandon focusing more on the credit union? That's where all that. No, it's not. I'm terrified. Is it going to happen? Yes. Are we going to do it? Yes. But it's the most going to the Supreme Court, suing cops, getting pulled over on the side of the road. I feel like a fucking shootout. A literal fucking shootout is less risky and less dangerous than what a credit union might do. I just. Maybe I'm wrong.
No, you're on to something. It's an invitation for parasites.
So I don't know. Are we going to do it? Yes. Am I scared as fuck about doing it? Yes. Is it like a dark hallway and it's creepy, but you have to walk down it regardless of what could be down there? Yes. But am I running down the hallway because I want to get to the end as quickly as possible because I think it's going to be so fucking awesome? No. Are we going to be able to manage and handle the problems associated with having a credit union? I hope so. If I didn't think so, I wouldn't be doing it.
Right.
So, do I think us having a credit union will cause the entire negotiable instrument system to collapse within like no time at all whatsoever? Quite possibly. Does that bother me very much? No. Obviously, that's kind of what we want. But we just need to make sure that if the whole system does collapse, we're not assisting the international banking cartel to create what they want, but we have to be sure that we're in the position to move it in this direction and create what we want, which is to go back to Article 1, Section 10 of the Constitution.
That's wise. I think it's going to be a meticulous process, not a ramming the door type situation.
Mm-hmm. I don't really follow much of what the groups do, so my plan is just to announce it in 3.0, give all the details, send 80 million people in there, cause people inside of the NCUA to literally hang themselves because they're so overwhelmed by people, and then just jam as many people in there as humanly possible, and then whoever is the 3 or so people that get out the other end first, they got me. That's going to be a much more effective use of my time, because if I'm sitting here trying to bang on this thing forever and it's just annoying, why would I do that when it's not a complicated process? It's just an annoying process. Really annoying. So I'm over here trying to figure out all these complicated processes because no one else is doing it. Why would I spend my time on something like this, which you have to have 7 people to put together a credit union? So it's like you and 6 of your buddies. All you got to do is just bang the door down. All you got to do is just beat the door down. That's how you open a credit union. It ain't complicated. You just beat, as long as you just, if you have a battering ram and you smash the door down, you've got a credit union. It's that simple, right? So I just don't see why I should be the one to have to do that. I just don't, it's not really, like, that's not what I do. I mean, that's what I do, but that's not what I do. Like I go in and I try to figure out really complicated, important things that no one else is really talking about, and then it's my job to go in and sort those things out. That's not what a credit union is. Credit union is a 15 to 20 minute application, a couple phone calls, and then you're through phase 1, and then phase 2 is just a whole bunch of weird, subjective, gay shit. And you try to ask them like what this means or what that means, and they can't give you a straight answer, and everything is just all up in the air, and they just kind of make whatever decisions they want, and it's just super gay. And it's like, what do you project your expenses to be? Do you have any people donating? The people who have donated, are they getting stocks? Are they getting dividends? Is it just a strict donation? What's the contract that you have with the donators? is the contract clear, that it's strictly basically like they just keep saying that they're concerned about making sure that the credit union doesn't just open and then collapse. But when I'm on the phone with them, I'm like, guys, I'm literally just gonna file a fucking oh my God, I can't remember the name of it. What's the document to get access to the Federal Reserve discount window?
Like the OC10 or something.
Oh
like
my
that?
God, the OC10. I haven't said it in so long. I've been on so many different projects. All I'm going to do is I'm going to get it open. I'm going to file the OC10. I'm going to have access to the Federal Reserve discount window, and then everything's going to go to the window without recourse qualified endorsement. And like they're just so like blown away by that conversation that it like freaked them out. It like freaked them out, right?
I can only imagine.
I'm like, I literally can't fail. It's physically impossible. I don't need even $1 from anyone. I don't even need $1 right now. I don't even need phones. I literally don't need a phone, and I can do this. And they're like, they've never ever heard anything like this. Then I talked to this dude who is opening up one of the credit unions that I work with. And he's like, bro, you scared the living fuck out of those people, bro. He's like, you can't do it like that. And I didn't know. And I'm just like, dude, I'm not playing stupid fucking games. I'm not gonna lie. I'm not gonna smile. I'm not gonna do stupid gay shit. I'm not gonna pretend that I'm a fucking retard. I'm not gonna pretend that I'm a fucking faggot. Oh, notes. I need notes so I can have notes. Oh, I have this guy, Bob, who's going to give me a bunch of fucking notes. And it's like, dude, I'm just not going to do it. Like, fuck you. Like, this is such horseshit.
They definitely want to bait you into it. That's for sure.
So other people can do that. Other people can pretend to be retarded and think that they need notes to do any of this. And then once they succeed, then we can do what needs to be done and what's real. It's that simple. And once the teams are ready for what's real and what needs to be done, then I can step in and confidently do what I do. But
on the other side of jumping through those horseshit hoops, that I suppose others will jump through if they want to link up with you.
Wasn't it you on the last show that we did that I pulled up the NCUA? Yeah, that's right. It was with you. Yeah, I remember that.
Yeah.
It's an online fucking form. It's right on the website.
Yeah, but what I suspected is exactly what you've said, and that's that phase 2 is jumping through a bunch of horseshit hoops where they won't define words even. You know, it's something as simple as that. Like what? I thought about getting into litigation with them, but maybe. I mean, I don't know if it needs to go that far. We'll see. If we can get 100,000 people just bashing in their windows and doors. If no one can get through phase 2 in, like, let's say 9 months after I release 3.0 and there's 100,000 people running through the doors, maybe we need to move into litigation and just start suing the NCUA. I have no idea. That it hinted me right into a segue. My next discussion point is an update on Contract Killer 3.0.
I think about it a lot. I started writing the outline, but it just hasn't bubbled all the way to the surface. But I think it's coming. I'll probably release it, shoot all the video, and release it before like August, I'd say. At this point,
what are the most significant deviations from 2.0?
The whole first section about citizenship is completely different. It's based off my book and the treatise on the word person. So that's all going to change, all of video 1 and video 2. The tax stuff, all the ROE is out. We're doing the 8822B now, which is very, very effective and has been for a long time. I don't see that changing anytime soon. And then we're also doing the authorization to giving the campus authorization to settle the account of the taxpayer using a bill of exchange that is processed on Fedwire. That's also been extremely effective for a very long time. Also, it's much, much, much simpler than the ROE or anything else. So due to its incredible power, incredible effectiveness, and mind-bending simplicity, it's been great for so long that's going to be what's on the 3.0. So it's just incredibly simple. We're going to go over trusts and So driving versus traveling, I wrote a whole page on the subject on my Williams & Williams law firm website. That's going to be the basis for the new trust and driving versus traveling section. And then with the negotiable instruments, I'm debating, I think rather than just go through all of UCC Article 3 like I did last time, I'm just going to go through the flow chart. And it's just going to be like maybe just one really long video of me covering all the information, the background, the case law, the entire flow chart all the way down. And then offering them, if they want to go back to 2.0, they can watch the 6-part series from 2.0. Because and then from that point forward, we'll do all that, and then from there forward, it'll just be litigation procedure from that point forward. So we're going to go through the rules of civil procedure. We're going to go through the rules of evidence. We're going to go through the rules of professional conduct. We're going to go through all of the judicial canons. We're going to go through basically everything involving procedural aspects of court.
Is we, you, and Joey, or?
I don't think Joey is going to be in this one because I think I've got it pretty well under control. It's possible he may come on. I don't know. But as of right now, no, I don't think so.
I gotcha.
He's still helping me with everything, but he's kind of doing his own thing too with the credit. He has these credit groups. So he's kind of branched off and kind of doing his own thing now. Not to say we're not working together. We most definitely are. But he has sort of helped me up and out of the nest. You know, I couldn't fly. He helped me fly, and then now I can fly. So, not to say that he's not needed or wanted, if you know, but I just don't think. And 2.0 was absolutely required that he be there because I didn't understand the information well enough to talk about it on my own. So, that's it.
That's great. What about your utility company case?
They have to get me, I have a meet and confer with them tomorrow. In fact, I need to make a quick note on that real quick. I have a meet and confer with the attorney tomorrow, and the discovery packet that I sent him is also due by tomorrow. So I'll talk to him about that over the phone. I have a feeling he's going to say fuck you about it, and then I am going to file in a motion to compel discovery. Be sure to motion to compel. Yeah, so that's basically where we're at with that. The city, it looks like the city wants to file what's called I don't even know how to pronounce it, a demurrer, which basically means that like they're not necessarily fighting the facts of the case, and even if the facts of the case are true, they're saying I have no legal basis to bring the claims. So it's like a motion to dismiss, but they aren't fighting against or filing in opposition to any of the facts of the case. It's the same thing that happened with Dred Scott in Dred Scott v. Sanford. He actually filed a demurrer in that case because I forget who was who. I think he was the plaintiff. I forget who was who, but the opposing party, which I believe was the government, said that he was unable to attain citizenship because he was not a free white person. Or no, I forget which way it was. But anyways, they said that he couldn't bring the claims that he was bringing. He had no legal basis for the claims that he was bringing. So they didn't even want to talk about the merits of the case, of the Dred Scott case. They said, okay, fine. All of this stuff that Dred Scott's saying may or may not be true. But the fact is that he doesn't have any legal basis for bringing any of these because he can't be a citizen, and he isn't a citizen because he's a Negro. And that was called a demurrer. And then that is actually what the Supreme Court voted on. So out of the 9 Supreme Court justices, 7 of them voted in agreement with the demurrer that Dred Scott never had any legal basis to bring his claims.
Now, didn't they cut your power off, and wouldn't that constitute a legal basis?
They're saying they have, and it's so funny because I'm hearing this more and more and more. I'm seeing a lot of other agencies and stuff doing this all over the country now. All of a sudden, to our people, they're using sovereign immunity. There's this explosion of this sovereign immunity thing that I'm seeing all over the country. It's not just in my cases. So this is a whole new layer, a whole new problem that I've been working on dismantling. So essentially, like, what we're doing essentially is just moving forward. We hit a barrier, right? The first barrier that we hit that was really, really bad, that has kind of been like a bear trap that we've been in for a long time, is two things. Number one is vapor money theory. Number two is sovereign citizen. We've been in those bear traps. I want to say that bear trap because they're kind of one in the same.
They're interwoven, yeah.
They're interwoven. Like, they always just say both. It's very rarely one or the other. It's typically both because they hey, look at that. Because I think they just find our other cases, the bar cards, and they're so fucking lazy that they just copy whatever it is that they see other people doing. So I think that's kind of where that whole thing was born. But I think it was December of this last year, fairly recently, I created a rebuttal that I used in my Ninth Circuit Court of Appeals case with Amex. Maybe that was in October then. Maybe it was in July or August or October, actually. August, when I created this. I created a template sovereign citizen rebuttal and a template
The vapor money theory.
Vapor money theory rebuttal. Screen sharing is not on. I just sent a request. I think you have to approve it.
Got it.
And I will show that to you. Can you see my screen?
Nope, not at the moment.
Let me see here.
I did enable it.
Give me just a second here. Stop video. What is this? Share. There we go. Entire screen. Share. There we go.
Cool.
So if we go to the Nation of the Amnesty Coalition, we go all the way down to the bottom, because all of my releases and all of my cases pretty much just go by date. It's kind of like unspoken. I don't say that. It's not like part of like the instructions, but basically like everything is in the order, typically, not entirely, but typically in the order of which it was released. Like the explanatory statement was the first thing I ever released. The 8822B was this, it used to be the ROE, but now it's the 8822B. So it's there, even though the 8822B was released a lot later than the ROE, but it's pretty much just an ROE replacement. So it kind of goes in that ROE slot. The authorization for the campus to use Fedwire to settle the account of a taxpayer, that was made later. Template to eliminate certificate of title driver's licenses, that was made later. Private irrevocable. Anyways, maybe the date thing's not perfect, but anyways, in terms of importance, in terms of date, it's kind of, so the last things that I really made were, we have the flow chart, we have the public-private sole proprietorship flow chart, which I need to work on that. It's not bad, but it needs a little bit of work, probably before 3.0. And then here we have the presumptive rebuttal definition for the term sovereign citizen, right? So this I may work on. I'm still pretty happy with it, but I think it may need a little work. So we have here, due to an undefined term being used in this case, I will hereby agree to the term while defining it. This definition is in itself a presumption, and if gone unrebutted with evidence becomes active for this case. This is hereby admittance of the term being usable, as well as it becoming a stipulated fact of status and law. And then the definition, the only definition I've ever seen of the term sovereign citizen from the actual legal system, which the FBI and all this stuff, all of those definitions are entirely irrelevant. If the FBI has a definition of what a sovereign citizen is, that definition is only applicable internally through policy and internal policy. So If an employee inside of the FBI wants to speak to another employee inside of the FBI, and they say the term sovereign citizen, chances are they would be using the definition from the FBI, as that would be a proper usage of that term. Once they interact or interface with the judicial system, that definition has absolutely no meaning. It has no relativity at all in the legal system. Now what we do is we look for a definition inside of the legal system. A definition at a lower court would be considered typically persuasive authority, unless you happen to be in that same zone. A definition from an appellate court would be much better. If you're not in that same circuit, it would be considered persuasive authority, but it's typically considered with a lot more seriousness at the point when it hits the appeals level. If you can find yourself a definition from the Supreme Court level, you've really hit the jackpot, because that is a definition that is fully applicable in all courts everywhere. So obviously, I wanted to find a definition of the term sovereign citizen from the Supreme Court level. So I thought to myself, well, where am I going to find a definition of something like that? The only places I'm going to find that is places where they're talking about citizenship. So I made a list of all of the cases, which there are very few, by the way, where they're talking in great depth about citizenship. And the one where I found, I had read it already by this point a million times, but by the millionth time, I was actually searching on purpose for a definition of sovereign citizen, and I just realized, hey, it's been right in front of my face the whole time. It's from the Dred Scott case. The words, quote, people of the United States, end quote, and, quote, citizens, end quote, are synonymous terms and mean the same thing. They both describe the political body who, according to our Republican institutions, form the sovereignty and who hold the power and conduct the government through their representatives. They are what we familiarly call the sovereign people, and every citizen is one of this people and a constituent member of this sovereignty. And in this case, he's specifically, right after this, talking about the difference between the term people and the term persons. That's why he keeps using the term people very specifically, because he specifically defined that the term people meant the white citizens of the states, and that's what he's referring to in this quote. And he was saying that in contradistinction to the word persons, which was referring to African-blooded individuals who are not able to attain citizenship of a state, right? Because they are not a free white person. So basically, what this definition is very interesting, because this is actually a definition of state citizenship. This is not a definition of U.S. citizenship, because U.S. citizenship did not exist until 1868. This case is from 1857. So people say, and Samuel Freeman Miller in the Slaughterhouse cases says that the 14th Amendment overturned the Dred Scott decision. That's correct. But it did not overturn this definition, because this definition has nothing to do with what's being talked about in the 14th Amendment at all. So the thing is that the 14th Amendment did overturn the operative aspect of the Dred Scott case, the operative aspect meaning Negroes can't be citizens. That was overturned, yes. But the definition that he gives here of what a sovereign citizen is, or what a state citizen, he's saying the same thing. This is still just as real and just as active as the day it was written in 1857. It's not overturned because it was not actionable, of which then was converted by some later case. Now, if you were to say that the section from Dred Scott talking about how Negroes can't be citizens, that would be totally inapplicable and irrelevant in a court case, because that is completely without legal power after the 14th Amendment, because Negroes can be citizens, but they're citizens of the United States, not citizens of a state.
And just to tie it back into the utility case, what is this sovereign immunity term that they're leveraging? Like, how does that apply to them?
I'm not entirely sure. I've tried reading some of the cases. I've tried to understand. It basically says that unless there's a specific statute, they're immune to tort claims. So I'm trying to understand what that means and how that works, and what's the difference between a statutory point of relief and, you know, the California Commercial Code is all statutory. So we haven't even had our meet and confer yet. We're going to have it tomorrow. but he pretends like he doesn't understand the complaint. And I'm just going to ask him straight up on the phone, have you tried to understand the complaint? We've talked about this complaint multiple times. It's the same attorney that was handling the federal case when I sued the city. So I've talked to him twice before on Meet and Confer, so I'm just going to ask him straight up, do you even want to understand this? Because I don't think he does. So if he doesn't want to understand it, then at that point, it's very simple. It's just a matter of ignorance of the law is not an excuse. Whether you know it or whether you don't, these bar cards tell us ignorance of the law is not an excuse, but then when they're on the ropes, they use that same faggot shit against us. That's not going to fly with me. I'm going to get in his face. I'm going to get right in his fucking face and tell him the exact same thing that they tell us. Motherfucker, you dumb, faggot, low IQ piece of shit. Ignorance of the law is not an excuse. How does that feel? How does it feel to have the same fucking nasty, molded bagel jammed down your fucking cock-riddled throat? How does that feel? How does that feel?
It does seem like they have to be playing dumb because you can't be stupid to obtain a bar card, you know, and you lay these definitions out so clearly, so simply, like I don't like making assumptions, but at the end of the day, it's like it seems to me they have to be playing dumb to some degree.
That's right. When I was in my small claims case, the judge understood the claim literally instantly. And what terrified him was the implications of what my claims would mean for the society, collapsing the society. All of his questions, I mean, he said at the beginning of the small claims case that he didn't read the complaint because I had attached a whole complaint, right? Mm-hmm. But man, I mean, so two options. Either option A, he did read the complaint but told me he didn't because he wanted me to explain it in person to make sure I wasn't just an AI retard, right. Which is totally understandable. Honestly, frankly, if I was a judge, that's exactly what I would do. So I can't get mad at him for that. In fact, I think that's very diligent work on his part if he was doing that. The second possibility is that he was telling me the truth and I just am so good at this shit that I can explain it in like literally 8 minutes without any notes. So that's the two possibilities. So either A, he did read the complaint. He realized very rapidly that I wasn't fucking around. And then that's because immediately, I mean, literally immediately his questions were like very concerning. Like I'm very worried and concerned about what you're doing. But not challenging me as to it being true or correct or possible or the law. He never once rolled his eyes, degrading comments, any sort of judgmental, even the tone of his voice, nothing. It was just, so do you believe that you don't need to pay your bills? But like a genuine question. Yeah. Do you believe that the government is supposed to pay your bills for you? Genuine question. What will happen if everyone in the society starts doing this? Those are the kind of questions he was asking later, right? But all the questions he was asking me were all like involving like the implications of what this will mean. That means he understood the claim. Because if he didn't understand the claim, he would have asked me aspects of like negotiation or aspects of like what makes an instrument negotiable or aspects like what gives a document value. Where's the consideration? He didn't ask any of these questions. So you got to think he's a small claims justice. All he sees all day long is boo-hoo, wah, wah, wah. This person ran into my car and I'm retarded. And I don't know anything about anything, and I paid $80 to be here. That's small claims court. Small claims court is not people in suits with briefcases talking about case law. So the fact that the small claims justice was able to understand what I was talking about in fucking 7 minutes, but yet a bar card who I've talked to multiple times and who's seen multiple complaints from me now, and everything's been explained in 4 or 5 different angles, can't understand any of it, doesn't understand any of it. That's ridiculous. Yeah. At this point.
No doubt. And then just for anybody who might not know what we're even talking about, the root of this case is a negotiable instrument case, right?
Yeah. And a negotiable instrument is an unconditional promise or order to pay, and the bills that I get, the municipal bills that I get each month, fall under the classification of an unconditional order to pay, which is also called a draft in the California Commercial Code. So when I receive that draft, I become the holder of the negotiable instrument, or the person entitled to enforce the instrument. And then at that point, I'm able to basically endorse the instrument just like you would on the back of a check when you deposit it into the bank. And then I'm able to tender that instrument back to the person, and technically it is a payment of actual U.S. currency. That's the whole thing in a nutshell, right?
Yeah, absolutely. Absolutely. You don't need to go any further on that. I just wanted to cover the root of the case. And if they want more information, you've got plenty of content on the internet.
Yeah. So with this presumptive definition of the term sovereign citizen, we have this definition referring to the Dred Scott case, applied to a, quote, free white person, end quote, who is a citizen of a state. And this definition comes before the initial birth of the U.S. citizen category in slaughterhouse cases, which was, I'm going to change that a little bit because it didn't. The U.S. citizen category was born out of the 14th Amendment, which no one really seemed to understand until that was all clarified in the slaughterhouse cases. So technically, the 14th Amendment created the U.S. citizen category, but the slaughterhouse cases was the first time anybody really even understood anything. It was like everyone was basically in like a fucking tizzy for 5 years until the slaughterhouse cases came out, and everyone was still kind of in a tizzy, but like it was the first like point where anyone could make heads or tails of any of it. Right. So I say slaughterhouse, but anyways, those are the kind of things that I go through these every once in a while, and I change them, clean them up, get more specific, and it just kind of it's a graduated process of me understanding it better and then explaining it better, right? So, and we have a quote about sovereignty, right? The sovereignty is often incorrectly defined as something individual, but as Mr. Taney has described above, the sovereignty is collective, and then individual sovereignty is enjoyed via that collective sovereignty. As a white state citizen, I have no right to the 14th Amendment at all, as clarified in a case that occurred the day after the Honorable Samuel Freeman Miller gave his opinion in the slaughterhouse cases. So slaughterhouse was April 14th, 1873. The very next day, we have Bradwell v. State. In this case, Mr. Miller says straight up that a white citizen of a state does not have any ability to use the 14th Amendment in any way. And he says right here, the protection designed by that clause, as has been repeatedly held, has no application to a citizen of the state whose laws are complained of. If the plaintiff was a citizen of the state of Illinois, that provision of the Constitution, meaning the 14th Amendment, gave her no protection against its courts or its legislation. Straight up. There are 3 distinct sections of the Constitution which describe how the original citizenship class in America was not a U.S. citizen, but was a citizen of one of the states of the Union. And then I give those 3 quotes here. The definition of sovereign citizen would only apply to me as a free white man and would not extend into the business that I own called a sole proprietorship. That business, defined as a person in 8 U.S.C. 1101 subsection B3, is a U.S. citizen under 8 U.S.C. 1401A and 8 U.S.C. 1101A22A. If the term sovereign citizen is used to describe the sole proprietorship, this would be fraud upon this most honorable court. There is no sovereignty, collective or individual, enjoyed by a U.S. citizen. The U.S. citizen class was originally created to federally protect the released Negro slaves after the 13th Amendment from state abuses, particularly the southern states, then was expanded to include legal fictions in Santa Clara County versus Southern Pacific Railroad Company in 1886. The above completes the definition of the term sovereign citizen unless rebutted. If gone unrebutted, the above definition will hereby become a stipulated fact for this case and will be entered into evidence by this most honorable court. So it gives them the opportunity to now rebut the above, which is literally completely physically impossible. It's not possible to rebut this. It's absolutely, completely impossible. But they're bar cards, they'll try. But it's all just snake horseshit bar card silliness. It's the bar card shuffle. You cannot rebut this. It's physically impossible.
Where do you, I
But
mean, if you had to guess, I mean, what do you think their settlement offer, or where do you see this going?
well, I've learned that with the bar cards, there's always something new. They're gonna always create something new. So if we go to my MX appeal in the Ninth Circuit, you'll see when I developed that when I used it. So the way an appeal goes in federal court, I'm sure it's probably the same in state court. I've never been to an appeals in state court yet. We'll see. But you do what's called an opening brief. So you'll see my opening brief here. Opening brief is like background. What is it that you tried to originally say in the original case? What were your objections to what occurred? And then like where is the what's called abuse of discretion, stuff like that. That's what you're explaining. You're explaining why I'm here and why I deserve to be here. That's the opening brief. This is why I'm here, and this is why I'm allowed to be here. So you have to have both of those elements in your opening brief. California actually has a form that you download off of the website, and it has all this already there, and it's called an appellant's informal opening brief, and it literally has instructions, and you just pull it up in your Word document, whatever, and you just fill in the blank, literally. It already has the number, and it already has the question, and it's like a very, very simple. What are the facts of your case? And all I did was just go through and plug in answers underneath each of the numbered thing and just fill that. It's very simple in California. Luckily, we have a very, very simple system. And then you don't even need to send in paper copies or anything. You just upload this to the Ninth Circuit online. And also the Ninth Circuit online submission, it's a totally different system than any other system, and it's like very updated and very clean and super, super simple and streamlined. Like you click a box and there's like a couple options, and then you type in the information, or it's already populated. Going to the Ninth Circuit Court of Appeals in California is tremendously friendly to new litigants and pro se litigants, and I mean probably by far the friendliest of all of the circuits that I've ever seen. So it was an extremely easy process. Contradisposed to trying to go to the Supreme Court, which is essentially like trying to survive being deployed in Vietnam for 4 years. That's a different story, right? But you go to when you start off, you file the opening brief, and then they file the motion to dismiss. They fucked around. That got thrown out. But typically, as long as they're not playing stupid fucking games, they're going to file what's called an answering brief. So what are they answering? They're answering everything in your opening brief. And that's what people don't understand about litigation. If you don't put the claims in the opening brief, let's say it's Wesley Snipes. If Wesley Snipes goes to court and he says a bunch of stupid ass shit and he goes to appeals, he can only talk about in the appellate court all of the stupid ass shit that he brought up in the lower court. He can't bring up new shit necessarily. But people think, oh, he went to appeals and he lost. I guess it doesn't work. I guess these things don't work. No, it's that the lower courts are only going to take whatever it is you say, and then the appellate court is only going to take whatever you said in the lower court. So if you don't say it, then it's not going to go anywhere, right? And I didn't really necessarily know that when I did a lot of this. So it's kind of all over the place and kind of goofy. It was kind of all part of the learning process. Some of it's in the original documentation from the original case. Some of it's not. I'm kind of freaking out trying to figure out what's going on most of the time, to be frank with you. But to be honest with you, then there's a reply brief, which is considered optional. A reply brief is a response by the original party who filed the opening brief. It's a response to the answering brief. And if you read this is when you can tell Brandon is starting to fucking get somewhere. He's starting to understand some of these things.
Yeah, it looks like the last action was like August of last year.
Yeah, so this is where this case has been since August of last year. This was the last filing into the case. The reason why I'm showing you this filing specifically is because you can see this is where I developed these definitions and presumptions
Gotcha.
and actually use them in the case.
Gotcha.
So you'll see that it's been adjusted a little bit on my website because I made a couple updates to it that you won't see here because this is the very, very first usage. But you'll also see here presumptive definition of the term vapor money theory under Rule of Evidence 301. So I got a bunch of great case law as regards to our negotiable instrument monetary system and how it works, right? This is pretty much probably one of the most important quotes regarding our financial system, right? By the Constitution of the United States, the several states are prohibited from coining money, emitting bills of credit, or making anything but gold and silver coin a tender in payment of debts. Article 1, Section 10. But no intention can be inferred from this to deny to Congress either of these powers. What they're referring to is the District of Columbia, which is not technically a state as per the definition in the Constitution. No state shall make anything but gold and silver coin a tender in payment of debts. Washington, D.C. is not technically a state, which is covered in detail in a case called... I just found it recently, actually. Hepburn and Dundas v. Elsie from 1805 covers it in detail that the word state does not include congressional zones. So that's their basis of the production of Federal Reserve notes is Article 1, Section 10 does not apply to the District of Columbia. That's exactly why in UCC 9-307, as well as in 4 U.S.C. 71, what is the definition of United States?
Corporation.
It's the District of Columbia.
It's located in the District.
It's located in the District of Columbia, right? And the reason why is because they had to locate it in a place that's not a state.
Right.
So United States is inside of a location that is not a state. That's how they got. But you got to think, why did they do this?
Well, that's the United States Inc. It's not the actual.
Yeah, but why did they do? They did this. They did this because they were trying to fund the war because the country was going to collapse if they didn't fund the war.
Yeah, you're talking about.
So there's a real reason. There's a real honest to God reason why this all took place. And when you start going into the history as to why all this took place, you realize this is a real thing. This really happened, right? And they explain here, this is another really fascinating quote. There was no coin, which they call specie. Mm-hmm. The term specie is referring specifically to gold and silver coin money. That's the term they used to use to dispose it or to relate it to paper money or negotiable instruments or unconditional promises and orders to pay, right? In general circulation in the United States between 1862 and 1879, both gold and silver were treated in business as commodities. The legal tender cases arose during that period, right? So then I go into the case law, and then our financial system is very simple, and then I just walk them through step by step. Currency is composed of negotiable instruments, unconditional promises, and orders to pay. A Federal Reserve note is an unconditional promise to pay between the United States, defined in UCC 9-307, and the Federal Reserve. The Federal Reserve is defined in a Ninth Circuit Court of Appeals case, which says very clearly that they are privately owned and locally controlled private corporations, and they are not federal instrumentalities.
Right. Like Federal Express.
That's correct. Negotiable instruments are exchanged and transferred by what is called negotiation. The basics of negotiation is the subject of endorsement, spelled with an I in the UCC Article 3, but spelled with an E, often in life. Endorsements fall into a few classes, blah, blah. So this is the generalized explanation of the basic functionality of negotiable instruments. And then at the end of that is when we get into where I'm redefining the term vapor money theory as an ignorant attempt at describing our current currency system as something more than being composed of unconditional promises and orders to pay in accordance with how those are defined in UCC Article 3, Section 104. This term is a very depressing and sad attempt to degrade a monetary system with a long and rich history, both in case law and without. This is an attempt essentially to gaslight people and persons who are attempting to use the actual law found in case law and in the various state-adopted commercial codes, which are typically close duplicates of the model UCC. This term attempts to derail any attempt at applying the commercial codes by making use of those codes appear to be frivolous. This term is a term of massive degradation and shows deep ignorance and maybe even contempt for our negotiable instrument system as well as the law. For those aware of the functionalities of negotiable instruments, which is well articulated by Article 3 of the model UCC, the term vapor money theory is offensive as it is a generic and ignorant attempt at invalidating all of UCC Article 3 and the entire legal basis behind legal tender and the operation of unconditional promises and orders to pay.
I see why this has been sitting since August of last year.
Yeah. So obviously, and then at that point is when I get into a point-by-point rebuttal of each major, what I consider to be major section of the answering brief. And then you can see the original point quoted, and then you can see the rebuttal below it. Yeah, this has been sitting since August.
So I have been loosely keeping up with that. One thing that I'm total retard on is the writ of certiorari. What is that about, and what is the difficulty or the challenge that you're having getting it accepted by the Supreme Court?
So the writ of certiorari is on the SBA case. So the SBA case started in California State Court, and then they removed the case from California State Court to federal court, which they can't do, because California is not part of the definition of a state court in 28 U.S.C. 1446 or whatever it is, the one that they use to move it. And I'll explain that. I'll show you that in the writ, right? I mean, this is obviously, like, if you thought the stuff we've covered so far is kind of more advanced, we're really getting into the advanced with this, right? So this is the writ of certiorari. You can get it right off of the Williams and Williams law firm website.
Let's get even more basic. What is the purpose of a writ of certiorari, and what does that even mean?
So a writ of certiorari is a petition, and it's involving very, very specific questions. So the very, very first thing is you're basically asking the Supreme Court very, very specific questions of which have different basis of operation by area or circuit.
There you go, right? That you're literally asking the same question I asked you earlier about sovereign immunity. What is that, and how can a corporation even have that?
Well, specifically, the way that I asked, it's very, very specific. Whether a corporation, which is considered a person, it was born in the United States, and it is a U.S. citizen,
right?
How can it have sovereign immunity? How can really more so than how can a corporation have sovereign immunity? That's one question. How can a U.S. citizen have sovereign immunity? That's the here's the smaller question is how can a corporation have sovereign immunity?
I see.
The bigger question is how can a U.S. citizen have sovereign immunity? Right. That's the big question.
Right. No, connecting those dots is important, because if, like you said, a 14th Amendment citizen can't have sovereign immunity.
Correct.
By definition in the 14th Amendment, and this corporation is defined as a U.S. citizen, so how can it have sovereign immunity?
Correct. Right. Saying, obviously, if you ask the question, how can a corporation have sovereign immunity? That discussion would change the country dramatically. But having the conversation, can a U.S. citizen have sovereign immunity? Oh boy. Right. That's like reset button level shit. That's like reboot level shit. That's like the biggest thing the Supreme Court has been asked in well over 100 years, probably since the fucking slaughterhouse cases.
Right. Yeah. 150 years.
So yes, it's asking a corporation, but it's specifically asking a corporation. It's kind of asking two questions, really. I guess you can kind of say it because the corporation is a U.S. citizen, but as you go farther in the writ, I talk a lot about how I shift the attention over to more along the lines of U.S. citizens can't have sovereign immunity. Corporations are not. It's kind of irrelevant. It just so happens that the SBA is a corporation, but it's the U.S. citizen aspect in relation to sovereign immunity it's actually the real concern, right? Because if that's the case, then every U.S. citizen has sovereign immunity.
Yeah.
If they want to play that game, then okay, fine. We'll flip it around on them.
100%.
Well, no, the SBA is a U.S. citizen. You guys gave him fucking sovereign immunity. I'm also my sole proprietorship's also a U.S. citizen. My sole proprietorship has sovereign immunity.
Yep.
Now what are you gonna do, bitch? Now what are you gonna do?
Yep.
So every single question and every single thing, no matter how they answer, they get fucked. And I'm not doing that. I'm not doing that out of revenge. I'm not doing that out of anger. I'm not doing that because I want to destroy them.
Clarity.
I'm doing that because clarity, and we need to talk about this and think about it and mull it over. And the thing is that it's all gay. That's really it. At the end of the day, it's all fucking gay. And I'm just gonna smash your windows in and smash your doors in until you realize and admit that it's fucking gay. It's gay for you and your family too. And that's the part that pisses me off. It's like, why are we not talking about this? Your family is fucked. Your children are fucked. Everyone's so beyond fucked. Like, you have nothing to gain by not talking about this. That's the part that pisses me off. The attorneys, the courts, it's like, dude, like, you have nothing to lose and everything to gain by talking about this. So I don't think of it as a me against them at all. I think of it as, bro, shake off the chains, man.
Right.
Like, you're just as fucked by this information that I'm trying to talk about as I am. And so when I say you're fucked this way or you're fucked that way, the definition of fucked is, yeah, you're wrong, but at the same time you're freed. So it's not like I'm trying to crush them, I'm angry at them or anything. In fact, if they would just stop being faggots for a second, they would benefit so much by the conversation. So it's not like
They're too busy taking things personally and being a victim to like hear the message.
It's just complete horseshit. It's like, you wouldn't bring a bunch of stuff to someone's table that you hate and it's all going to like make their life and their family's life like way better. It doesn't make sense, right? So I'm bringing all the stuff to the table that's going to make their life and their family's lives and their grandchildren's lives and everybody's lives so much better. And it wouldn't make sense that I would do that to someone that I hate. So it's kind of a weird situation. Like, is it adversarial? Yeah, but you're not up against the person, you're just up against the ego. That's it. The enemy is not the person. The enemy is the ego of the person, right, that's preventing them from realizing the massive beneficial gift that I have just placed right in front of them on their table.
Conflicting beliefs also causing gridlock in the mind.
That's correct. So they're not my enemy. It's their ego is my enemy. Mm-hmm. But you know, so that's kind of how
but their ego is what's holding them back too. So it's kind of like correct. You're actually being a friend.
So it's a little bit kind of a weird thing, right? So when I say they're fucked either way, that's what they're fucked in terms of like getting released from prison. You're gonna get released from prison one way or the other. So, you know, whatever I have to do to get this done, like, that's what I'll do. You know, so then question 2 is whether a government corporation has sovereign immunity from suit when it can. So if you look up, like for example, I was looking up the City of Glendale charter. It says right in the charter that City of Glendale can sue and be sued. And then it says in a court of competent jurisdiction or whatever it says. That second part is a little bit different depending on where you look. But if you look in, every single government corporation has a section in the United States Code that is all of the stuff about how that particular government corporation operates. For example, in the SBA, which you'll see me cover it here in the Writ of Certiorari, it has a general provisions section. And it's talking about how the SBA is being created as a government municipal corporation. What are its duties? What are its obligations? What are its rights? And it says right in there, it can sue and be sued. So how is it that right in the literal charter of the SBA, it says that the SBA can sue or be sued? How in the hell did this thing that literally statutorily can be sue or be sued gain immunity somehow? It doesn't make any sense, right? That's the second question. And then the third question is whether a removal from state to federal court can take place under 28 U.S.C. 1442 when the originating court does not fall under the definition of a state court, which is defined in that same subsection.
Right. And that's where things get interesting because the Republic is kind of existing as a shell right now.
Yeah, so they removed my case. Well, it's more complicated than that because the state of California is technically a U.S. citizen, but I'm pretending to not know that here. There really is no Republic courts.
That's what I'm saying. It's just a shell that's not being really operated. I mean, it does exist on paper, but the color of law is just...
They pretend as though
suffocating it.
California courts are Republic courts when they're not. So that's kind of... I'm just kind of playing into that a little bit.
Right.
Because I just want to get the discussion started, but the actual truth is there is no state courts. That's the actual truth, right?
Right. They're all U.S. citizen courts, basically.
So here's the background. That's just the background of what happened. So you can very quickly read that and get up to speed if you don't know what's going on. Basically, I was in district court. I was in state court. It got removed to district court, went to appeals, and then here I am in Supreme Court. That's the short story, right? Here's all the... You have to list all the cases. This is part of the rules. So I went through the Supreme Court rules and I just followed all the rules. You have to list all the cases that are mentioned, and then you have to list each page number that each case is mentioned on. Same thing with statutes and constitutional provisions. And then obviously I downloaded 5. I went on Grok and I said, please give me PDFs of the past 5, the most recent 5 writs of certiorari that were accepted for oral argument by the Supreme Court. And it gave me all 5, and I just read just 5 of them. And that gave me a full overview of everything that I needed and what they're looking for and how they were structured. Because you got to think, less than 1% of writs are picked up by the Supreme Court. So I wanted to look at some that had been picked up and see if I could figure out why or what was unique about them that made them something that the Supreme Court wanted to pick up, right? So then I just wrote an introduction. Brandon Joe Williams, a state citizen of California, non-U.S. citizen and free white man, became aware of the functionality of negotiable instruments, which are unconditional promises and orders to pay, negotiation, endorsements, etc., after having taken on a, quote, loan, end quote, with the United States Small Business Administration via his sole proprietorship and U.S. citizen, named all caps Brandon Joe Williams registered trademark. Once he understood that the original notes that were issued to secure the original loan had actual monetary value and could be swapped at the Federal Reserve discount window using the provisions of 12 U.S.C. 412, he realized that the loan itself was instantly fully satisfied due to the original notes being the, quote, collateral security, end quote, quoting 12 U.S.C. 412 to fund the loan. Originally, due to this being a primarily California Commercial Code complaint, this case was filed in a California state court. The case was then improperly removed to federal court under this statute, even though that the originating court does not fall under the definition of a state court in accordance with the definition from D6. And it's also echoed the same way in Rule 47 of the Supreme Court rules. This case was then subsequently dismissed in a federal district court for sovereign immunity, then also dismissed from the Ninth Circuit Court of Appeals for summary disposition regarding the same incorrect idea. The definition of a state court from 28 U.S.C. 1442 D6 says, includes the Superior Court of the District of Columbia, a court of a United States territory or insular possession, and a tribal court, a.k.a. any court within the exclusive territorial jurisdiction of the District of Columbia or the federal government, which would not include a California court at all. California, even if you type it into AI or Google, if you type in, is California under the exclusive territorial jurisdiction of the United States, even Google will tell you no. It's not rocket science. And then we have Rule 47 of the Supreme Court rules. It says here the term state court. This is right out of the fucking Supreme Court rules. Rule 47. The term state court, when used in these rules, includes the District of Columbia Court of Appeals, the Supreme Court of the Commonwealth of Puerto Rico, the courts of the Northern Mariana Islands, the local courts of Guam, and the Supreme Court of the Virgin Islands, all of which are areas under the exclusive territorial jurisdiction of the United States because they're all territories or insular possessions. They are not states, as per the definition given in that same case, that 1805 case said earlier. None of these are states, as per the constitutional definition. Anyone born in any of these areas, they wouldn't be state citizens, they'd be U.S. citizens, right? References in these rules to statutes of a state include the statutes of the District of Columbia, the Commonwealth of Puerto Rico, the Commonwealth of the Northern Mariana Islands, the Territory of Guam, and the Territory of the Virgin Islands. So it makes no mention of any area outside of the exclusive territorial jurisdiction of the federal government, such as California. Any presumption that the definition somehow magically includes other things outside of that definition was heavily rebutted by the sole proprietorship in all the cases and appeals involved in this. This is a massive and terrible situation that is being misapplied in literally every single circuit of our glorious nation. This is an alarming situation which should be considered a national emergency. Then, as regard to my other question for the Supreme Court, the United States Small Business Administration, this is where, in my opinion, this is where things get hot, spicy, crazy. This is a wild, wild question, right? So listen to this. Is a corporation under the United States and as a person under 8 U.S.C. 1101 subsection B3 and U.S. citizen under 8 U.S.C. 1401A does not in itself have or need sovereign immunity. The idea that a U.S. citizen would have sovereign immunity is an unfounded idea and has absolutely no basis in law. I will prove this conclusively in this writ. Jurisdiction. The petitioner of this writ, sole proprietorship, being a U.S. citizen, only has access to the Bill of Rights via the 14th Amendment and the incorporation doctrine cases that incorporated certain points of the first 10 amendments under the 14th Amendment. The owner of the petitioner, me, Brandon Joe Williams, as a white citizen of California, has no additional protections due to the 14th Amendment, as clarified by the Honorable Mr. Miller in a case that he delivered on the day after he delivered the slaughterhouse cases. That case is, we covered it earlier, Bradwell v. State. Brandon Joe Williams has direct and unabridged access to all of the first 10 amendments without regard to any aspect of the cases involved in the incorporation doctrine or the 14th Amendment. This includes the 3rd, 7th, 9th, and 10th Amendments, which have never been incorporated for U.S. citizens. So this is where we get into the statement. This is where we start getting into the meat and potatoes of the claims. Federal courts operate under 4 U.S.C. 71 and 4 U.S.C. 72, which is basically all offices attached to the seat of government shall be exercised in the District of Columbia and not elsewhere, except as expressly provided by law. So all federal courts operate essentially as though they are in the District of Columbia. So a federal court in California doesn't operate under California law. It actually operates under the laws of the District of Columbia, essentially, in essence, right? And you say to me, well, Brandon, state of California also operates under that same. Yes, it does. But when the republic is reborn, we'll still have federal courts. So like when the republic's reborn and we have state citizens and we have a governor who's a state citizen, the federal government will still have federal courts that will be inside of California, but the land that the federal courthouse is on essentially legally will continue to operate as though it's in the District of Columbia under 4 U.S.C. 72. That's the way our country is supposed to operate. So as soon as you drive right off the street and into the courthouse, in law, you just went from California and you're now in the District of Columbia.
Right.
It's always been that way, and it will always be that way. So that is not something strange or nefarious that will change.
But as of right now, technically, when you're in California, you're really in the District of Columbia.
So that's where it gets complicated, because a resident of California is technically in the District of Columbia, and then when they move into the courthouse, they're still in the District of Columbia.
Right.
They don't. So they're both of those things fall under 4 USC 72. But once the republic is reborn and the republic creates a relationship, and we get our country back on the rails, the federal courts will still continue to operate in the various states, and those properties that the courthouses sit on are essentially legally little tiny plots of land that essentially when you go on them, you're essentially in the District of Columbia, basically.
Yep.
The thing is, though, is that we are essentially the grantors of the trust that created the District of Columbia as state citizens. So if a state citizen goes on to land that operates as though it's the District of Columbia, that doesn't mean that we lose our rights or anything. In fact, it actually means that we're going from an area where the other white people are on the same plane as us to we're moving into an area where we basically have more status than the people that are in that zone. So it's actually the opposite of what it is now. Typically, people move into a courtroom and they think, oh, I got to behave. You still need to behave. You still need to be respectful. These people work for you at that point.
Right.
So if you're a state citizen and you're in California, you're driving around, everyone else is kings and you're a king, sovereign citizen, right? Members of the sovereignty. If I saw you in California, you're at the same level as I am in California, right? So the mentality shifts to now I'm moving into a zone of people who work for me, who are all my representatives, who work for me, who are essentially U.S. citizens or whatever. But the problem is that when the U.S. citizen class is destroyed, the employees of the government will no longer be U.S. citizens. They'll be state citizens that are operating as representatives of that state in that zone. So once we fix everything, that's also going to change then again, because then the people that are in the District of Columbia, their citizenship will tie into whatever state they come from because they are representatives of that state. So then at that point, the District of Columbia will come up to the same level. So right now, everyone's down here. As we're fixing things right now, we're going up here. And then once we eliminate the 14th Amendment and the U.S. citizen class, the District of Columbia will then rise to our level. They don't lose their state citizenship just because they work in Washington, D.C. That's only possible because of the U.S. citizen class.
Right.
Before 1868, everyone in Washington, D.C. was just white citizens of a state who are just operating in a representative capacity on behalf of the people of their state. They are speaking, if anything, they're not higher level state citizens. It's like a bunch of kings, and then all the kings decided which king they want to represent that kingdom in foreign lands. And then Washington, D.C. has all the kings that all the other kings sent to come and represent all of these 50 kingdoms. And then Washington, D.C., with all of the representative kings, represents all these kingdoms internationally. That's the way the system's always been, and that's the way the Constitution is written. And that's why I get so upset, because people think America's gay or all fucked up or like not a great country. If it operated the way it was supposed to, if it operated the way that it was written, no one would have a problem with it. And if anyone did, we should just shoot them because they're fucking retarded. So the thing is that America is perfect. It's the perfect woman. It's just she's been abused terribly and forgotten. That's all it is.
Understatement, right? Understatement, but true.
So
yeah, go ahead.
So then I go on talking about a state of California is not within the exclusive territorial jurisdiction of a federal court. This is made abundantly clear in this quote by the Honorable David J. Brewer in Caja versus U.S. He just talks about this. right here. The laws of Congress in respect to those matters do not extend into the territorial limits of the states, but have force only in the District of Columbia and other places that are within the exclusive jurisdiction of the national government, which would be all of the things that you saw listed earlier in the definition of state court and in Rule 47 of the Supreme Court rules, areas such as Guam, Puerto Rico, the Northern Mariana Islands, the Virgin Islands, etc. The states are all individual and sovereign, each one being a separate nation in itself with its own citizens and government. In order to be a citizen of a state, you need to be what's called a free white person, in accordance with how it is described in the Naturalization Act of 1802. This is made abundantly clear by the Honorable Justice Henry Billings Brown in Downs versus Bidwell when he said, quote, "We have in this country substantially or practically two national governments. One is to be maintained under the Constitution, which is the Republic, with all its restrictions. The other to be maintained by Congress, which is Washington, D.C., outside and independently of that instrument, by exercising such powers as other nations of the earth are accustomed to exercise." And this is actually constitutional, what he's talking about. The problem is the U.S. citizen class is what fucked all this up.
Yeah, so are you advocating for just eliminating that altogether, and then for the people who are currently just United States citizens and not state citizens, finding ways to naturalize them as a state citizen?
Correct.
And what is, so that's actually was my next discussion point, because immigration is the hot topic, and I do want to start talking about more philosophical and like social issues.
Well, let's go ahead and read this. I don't think I've ever really read this on a show, so this is very special. I think you'll get a lot of viewers if I just go through this. I've never really, I don't think I've ever gone through this writ, and there's a lot of talk about it right now because it's kind of blowing up on my shit.
And didn't I see a post where you're having somebody help you get it through now?
I just hired a guy yesterday, a team, so we're going to get this thing through. And I just got a box back from the Supreme Court yesterday as well. Randomly 5 months later. So it's all coming together pretty magically. Right. This is definitely getting into the Supreme Court is definitely one of the hardest things I've ever done. There's no question about it.
In the status of this case, was it dismissed at the federal level and that's why you're doing this, or is it just kind of...
It was dismissed at the federal level and also at the Ninth Circuit Court of Appeal level. So to go to the Supreme Court, there are various ways you can get what's called original jurisdiction from the Supreme Court. I don't know a lot about all that. I've never even seen anyone do that successfully, so I never really bothered to even try to learn all that.
Right.
But typically, someone will start at the district level, just file a federal case, just, that's your ground floor. From there, you would obviously object to anything that you're not happy with in order to preserve the record for appeal. Objections is basically essentially what the appeals court's going to be looking for. If you don't object and you go to appeals, there's basically like they basically from their viewpoint, they look and they don't even see anything that they can even look at. It's like everything. It's like the Epstein files. Everything is blacked out except the areas where there's objections.
That's on my discussion list near the bottom. We'll get to that.
So if you think about it like that, all of a sudden the relationship and what you're supposed to be doing makes perfect sense. If you're not objecting, then you have no grounds for appeal. If you're objecting, then you have grounds for appeal. Once you go to appeal, you want to bring up all your objections. It's that simple. That's really the whole thing in a nutshell. Again, I've been trying to learn simple ways to explain all this, to try to get it into 3.0, try to simplify the ideas behind everything, try to take this big complicated thing like going to federal court and then appeals court, and how do I boil that down into something very simple and bite-sized, right? It's kind of like what I've been trying to do, right? So once you go through the appeals court, that's when typically when the option to file a petition for a writ of certiorari becomes available to you. And then less than 1% of all of the people filing petitions for writ of certiorari per year, which is typically between 7,000 and 8,000 filings, are approved by the Supreme Court for argument. And people say that's crazy and fuck the Supreme Court and they're all fucking pieces of shit and blah, blah, blah. Well, if you took the time to understand the amount of effort and time that they put into each of those very few cases they take per year, it begins to make more sense. They don't pick up cases that they would like to talk about over a weekend. They pick up cases that they want to tear through like wild bulls in a china shop and really get to the bottom of it. And they're very verbose and very detailed about all of these specifics regarding it. And if they feel that these specifics regarding it have already been covered in detail, or if they feel as though, like right on their website, it talks about what are they looking for? They're looking for what's called circuit splits, which means this circuit behaves and thinks this way, and this circuit behaves and thinks this way. They're looking for stuff like that, areas where there's a split. And then they're also looking for anything of national concern or effect. So if something would have a huge effect on like the whole country as a whole, the larger the effect on the country, the higher the chances that they will pick up the case. So then you look at mine.
I was about to say, I hope so.
So mine is probably the most that this country could be effective. The most that it would reboot every single area of law and cause the entire United States Code to be completely rewritten. It would cause basically all charters for every single state government to lose their charter. I mean, it would have more national effect than anything the Supreme Court has seen since the slaughterhouse cases, in my opinion. But the problem is that it's so extreme that it's terrifying. So there's also that aspect. I would say there's a very, 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 very low percentage that the Supreme Court will be picking up this case, to be totally honest with you. I think it's possible. I don't like saying this kind of stuff and getting into this stuff too much. It's possible that it would literally put justices' lives in danger to pick up this case.
Yeah, there's that factor.
I would literally go that far. But I said I was going to do it. So that means it's going to get done. End of fucking story. I want to do it. It's been an amazing learning discovery. It's been an amazing. I've read so many Supreme Court cases. My heroes at this point are Roger B. Taney, John Marshall, Samuel Freeman Miller. My fucking heroes are Supreme Court justices. So being here and interacting and putting these little booklets together and doing all this stuff and making it look like how the submissions were, over 100 years ago with the way that it's formatted and everything. People think that's, it's horseshit and formatting, blah, blah. I actually find it super fascinating because I feel like I'm going back in time 120, 150 years. Everything has to be paper. I'm having to go down and get booklets printed up. And I don't know. It is a pain in the ass, obviously. Huge pain in the ass.
Is the purpose of the margins for them to make notes?
Yeah, yes. But it's also, a lot of it's historical. So there's historical aspects, and then there's obviously notation aspects. It's both. Yes.
Gotcha.
So here's the next point of the writ, number 3. There were many cases, some very strange, that determined who was a free white person and who was not. A great example is In re Nijour, which is from 1909. This is the case where there was a Syrian who said he was a white person, and the court said no. So the Syrian was smart, and he went and got, I think one of his Syrian brothers or something like that was a lawyer. And the Syrian brother went into court and said, okay, do you know where Jesus Christ comes from? And the judge said no. And he said, modern day Syria or something like that, or like the Mother Mary or something. So basically, he pitched it. His argument was, if you say that this guy, the Syrian guy, is not white, you're literally saying that Jesus Christ wasn't white. And that flipped the case. So that's actually how he won. Yeah, it's really, really funny.
Oh man, they were gonna protect white Jesus like none other, man.
The judge probably would have been literally killed if he would have made Jesus not white. Like, I'm not kidding. He probably would have been actually murdered.
Yeah.
So what's so beautiful about it is that the lawyer didn't threaten the judge at all. It wasn't like, I'm going to kill you or other people are going to kill you. He's just like, hey man, if you want to make not white Jesus,
yeah,
good luck.
Yeah.
And the judge was like, Okay, Syrians are white, and literally Syrians have been white ever since, right? So it's a very strange, wild story.
I mean, biologically, race is a pseudoscience. I mean, socially, I understand it has real impacts, but biologically,
but
it's
this
not even
case, what's so unique about this case is typically a free white person is considered somebody of European descent, right? But Syrians are a complete outlier to that. So I was like, how in the fuck?
Weren't the Moors included in that too?
Well, that's actually that was already in the definition, the Moorish people, right? But of Spain, the Moorish people of Spain.
Not of Northern Africa.
Well, I don't know. Well, Northern Africa is in the definition. I'm not going to get into that stuff. Is so I don't even think it's
arbitrary as fuck for sure.
Oh, dude, I just don't even that stuff is where I start to lose interest because that is just I don't even feel like that information is even functional.
No, that's where your post and I'll read it. White privilege in America is so far beyond what any liberal could even hope to comprehend. Take the most bleeding heart liberal in the world screaming for equality, and they aren't even in the right galaxy. It's so far beyond that, it would melt their brains. Times it by tens of thousands, and maybe you'd get close. You're 100% on point with that.
Exactly. The 9th and 10th Amendment is, the 9th and if you want to go a step farther and be very simple about it, there's more to it than this. Obviously, the people who watch my stuff know this, but I like one-liners. I like shockers. I like Schwarzenegger one-liners. I'm starting to kind of get into that because it's kind of fun. It creates excitement. It creates interest. It creates a discussion. I don't say it.
Is that the whole point behind your like racism stuff too? Because when I read stuff like I just read, it's like I kind of understand the marketing angle of the racism stuff, but clearly you're not racist or you wouldn't be putting this information out in the public.
Yeah, it's everything I do is in an effort to get discussions going. But I'm very clear about that in the Code of a Pickletarian. That's what a Code of a Pickletarian does. What a Pickletarian does. A Pickletarian gets people talking about shit and then gets people doing shit. It's really that simple, right? Yeah. So all I'm trying to do is just get people to talk about it. I don't like ferocious, destructive people killing each other and arguing. But if you notice, there's very little of that in my stuff. If someone comes on and they say something terribly ignorant and I can tell they're going to do nothing more than poison my comment section, I just block them. It's very simple. Yeah. I block a lot of people. But they have to be of that category where it's just this person is literally just poison coming. And you can just tell it's obvious.
Yeah.
And if it's not completely obvious, I'll typically occasionally I'll do like one rebuttal comment or one response comment to test and see if they're one of those kind of people. But I don't even do that much anymore because over the past 4 years, I've realized that 98% of anyone who's that close to being automatically in that category, when I respond to their shit and then they respond to my shit, it's super obvious by that point that they are. So it's like a 2% chance basically that they aren't. I'll give people the benefit of the doubt every once in a great while, but these days I just don't even bother. It's just a block. If it's anything even close to like total horse shit, it's just a block. I don't even. And then sometimes I'll have people come on other platforms. I had a guy a couple days ago come on X and he said, "Hey man, I really wanted to apologize. I put some stupid shit on your Facebook. You blocked me. I've looked at your stuff. It's really, really amazing. I want to apologize. I hope you don't block me here." He's not going to get blocked. He's not going to get blocked. I didn't block him. I hearted the comment.
Genuine remorse.
Yeah. I hearted the comment, and I don't think I said it. I think the past few days I haven't been able to comment on X. It says failed. So I think I tried to respond and say, "Hey, no problem. Happy to have you here." But I don't think it worked. But anyways, my point is, typically there's very few of that. So overall, there are a lot of really cool, meaningful discussions that are happening now on the subjects. That's really all I care about.
Hell yeah.
So with that said, the ultimate, like the 9th and 10th Amendment is white privilege.
100%. But no, the whole thing is white privilege.
The whole thing is white privilege, but really,
when you talk about the fact that those two amendments weren't incorporated into the incorporation doctrine,
they never even talked about it. It was literally just fuck you from the very beginning. You fucking slaves are not getting these ones.
Right.
We'll talk about the first 8. Let's have a discussion. Oh, no problem. We'll give you most of this one. We'll give you this entire one. We'll give you this entire one.
Well, the right to bear arms was like, what, 15 years ago, something like that?
Yeah, that was 2010, McDonald versus Chicago.
I mean, it took a while.
They're talking about this thing now. The Supreme Court can people who habitually use marijuana gummies or something like that possess guns. Have you seen that one? They're doing oral arguments right now about that. I guarantee you, if you dug into that case, it's an incorporation doctrine
100%,
case
100%,
that will quite possibly overturn McDonald v. Chicago from 2010. So if it overturns McDonald v. Chicago, then the U.S. citizen class had the Second Amendment from 2010 until 2026. So it would be removed from the incorporation doctrine.
That much more important for people to get onto this state citizen information.
So the 9th and 10th Amendment, man, I've had a few reports recently of black men talking about the 9th Amendment in court, and they tell me that the court gets really, really fucking weird about it. Like, they want to get off that subject, like, really fucking fast.
Right.
And the reason why is because if people found out that blacks can never, ever have the 9th and 10th Amendment, every liberal group would go completely ape shit. It would make the BLM riots
we might
of
actually
George
get that
Floyd.
28th Amendment.
Dude, it would make the George Floyd riots of BLM look like Central Park on a sunny day with like chirping birds and shit.
Yep, 100%.
So I think that's why they get so nervous. But who knows?
No, because I mean, what are their two choices? You can either tell them that they don't have the 9th Amendment because you're not a free white person. That's I mean, you're literally sparking a stick of dynamite by doing that. Or you're granting it to them, but then at that point, that creates a slip where you're granting it to anybody.
They can't grant it. That would be an abuse of discretion. They can't grant it. It's physically impossible. They can't grant that.
I mean, if he claims to be a free white person, though, because then
there's some people doing that too, right. And that's
then you have to rebut.
I love it.
Yeah, then you have to rebut that presumption. Yeah,
I'm like, dude, I'm the biggest fan of a black guy.
Yeah.
I am the biggest. I want to see a gigantic Nairobi black guy with like the darkest fucking skin on the planet, with like a thick African accent, who was born in America, go into the fucking courts and say, I am a free white person and citizen of Utah.
Free white man.
Bro, if I was in the fucking court, if I was in the jury, I'd be like, God damn it, fuck it. I'm giving it to him. This guy's got Dred Scott level balls. I'm a fan. Whatever he did, unless it's like rape or child diddling or something real crazy, he's okay in my book. You know what I mean?
Well, even in that case, I mean, at that point, you're damaging in somebody's actual.
That's what I mean.
People or property. So even a free white person would be fucked.
That's what I mean. Obviously, that kind of stuff wouldn't fly. I would like to see him hang personally, regardless of skin color. But I'll hang a white man right next to a black man. In that case, you touch kids, we'll have a whole wind chimes of different skin colors, and they'll be hanging from the tree. That's how I look at it. I don't see skin color. I just want to see dead bodies at that point. But besides that, my point is, we are starting to see a little bit of that. And I'm starting to get a few reports that are trickling in. So we'll see. The courts do not have any clue what to do, apparently.
Pissing their pants.
I mean, they are just like, it's like throwing a flashbang in the middle of so I think the courts are going to, dude, I had a report. You will not believe this. I had a report 2 days ago, I think it was, of this lady who got pulled over, and she's pretty smart. She knows this stuff pretty good. I was kind of shocked. She's messaging me, and I was like, damn, it's actually pretty rare that I have someone message me that I actually know what's going on. Pretty impressive. She got pulled over. I'm definitely not going to say her name or anything. I don't know if I just never do. I always just stay on the safe side and don't give any private information out. Right?
I would do the same.
So she has a daughter, and the daughter had a school uniform on. And she told the officer, I'm not a resident and I operate under the non-resident codes, which is exactly what I teach people to do. So it's very rare that someone actually does it. So I guess what happened was the officer went back to his car. He must have used AI or something like that. He came back and he said, your daughter has a uniform for a public school. And her being in public school makes her a resident, and it also makes you a resident under the vehicle code. And I literally, when she messaged me this, I went, holy Jesus. Because that's the very, very, very first time I have ever heard of an officer actually listening, actually receiving the information, the proper information that I actually tell people to tell the officers, going back to his car, doing a little bit of research, finding an actual thing that actually does rebut what she said, coming back to her and respectfully telling her that I was literally like, oh my God.
You got
literally
hooked into this jurisdiction.
Bro, that's the first time I have ever been sitting in my chair reading a message being like, holy shit. Holy shit. Because if this is true, that means there is a huge shift occurring in law enforcement. Either this is either a one and done, one off situation of just a very fascinating officer that I would love to buy a beer for, frankly. That's just wild. Or maybe there's some sort of informational type thing coming down stating that, these sovereign citizens sue everybody under every single circumstance, and you have to be a little bit more careful and understand the law a little bit better. And they're having the officers actually kind of maybe use AI to sort of field certain specific, maybe they're being ordered to be a little more specific because they have to look like they're at least trying on the body cam. I don't know what it is, but it just kind of indicated the possibility that we're starting to see a shift. I don't know. I found it absolutely fascinating that occurred. So I don't know. I'm still kind of thinking about it a lot. Like, holy fuck. Like, and then afterward, she did more research and found out that her daughter is in a school that operates under the public schools scheduling system. So it uses the public school scheduling system, but it isn't legally under the definition of a public school. Oh. But at the time when she was he said that to her and she was like, right? And frankly, I would have been. I mean, I have never, ever heard anything from anybody that made me go like that. That was the first time I had ever heard something that would have stopped me cold in my tracks. I would have been just, I don't know what I would have been. Wow. I would have shaken the officer's hand. I would have been like, well, I'm going to need to do some more research on this. So you do what you need to do. Let me go ahead and sign
this without recourse.
You do what you need to do. And just know that if I can find a way around this, I will be coming for your badge or whatever. I'm just letting you know. You can look up my name. You see a million lawsuits. Do your thing. Do your thing. Do your thing. You know what I mean? I don't know. If you're right, then I am fucked. If you're not right, I'll be coming. Just letting you know. But it wouldn't be like a dickhead thing. It wouldn't be like, just like real simple. I'm just letting you know. You might be right. It's very, very good what you just said. You might be right. If you're not, I'll be coming. So do whatever you want. Do whatever you want. I'm not contracting with you. I'm not like, but you're gonna do whatever you think you need to do under force. So under stress and duress, I'm not gonna stop you. And what you just said is very fascinating. I need to do a little more research, but if I do research and I find out that, this isn't quite correct, then I'll be coming. You'll be seeing me again. You'll be seeing my face in the deposition. No question about it. But yeah, anyways, so yeah, I mean, I hear about some new stuff every once in a while, Obviously the whole plate thing. Did you see the video on the plates I just did?
Mm-mm.
I just did a whole
Oh,
critique
you
video.
talking about, okay, yeah.
Yeah, so, we got stuff like that going on. The cops have been way more chill about my plates recently. Like, way more chill. Like, yes, there are still like ultra freak out stuff that I am getting reports on, but it just seems like those reports are going down suddenly and dramatically a lot from what they were before. I don't get so out of all the people who have my plates, a very small percentage get hassled, but typically the ones who do get hassled, it's this whole 8-car fucking SWAT team disaster, right? Not literally SWAT team, but like almost on that level, right? Like GTA, like 4 stars.
Yeah.
Whatever's before the helicopter, 3 stars.
Right.
Okay. So, very small percentage of people fit that class, but the people who do, it's very explosive, right? They act as though you're like a murderer, essentially, by having these plates, right? Recently, that small percentage of people who have issued with the plates, there's been a massive decrease in that small percentage of it being this big, huge, explosive, crazy 3-star experience. And when I say massive, I'm talking like 60, 70, 75% less. So of that small percentage of people who are having problems, the intensity of those problems has reduced 70%, probably starting in January of this year.
That's good to hear. That means the information's getting to the police.
I don't know. I don't know what it means. It does seem positive.
I was about to say that's statistically significant for sure.
Now the other thing you got to think of that's really fascinating is they have stolen. They say collected. I say stolen. My plates, our plates. I think of them as my plates, and I also kind of think of it as our plates. I think of it kind of both, but I usually just say my plates. My plates. Because like I even think of like when someone buys my plates, they're still kind of my plates, even though they're their plates. It's like our plates. I don't really know how else to really describe it. So, so my plates. So we've had my plates stolen off of many vehicles, and many is relative to the small percentage who has issues. So if I were to put an actual number on it, I'd say several dozen, or maybe 50, between 30 and 70, maybe.
Gotcha.
Out of the hundreds and hundreds and hundreds and hundreds and hundreds of people that are using this plates, I'd say maybe 30 to 50 or so have been stolen off the cars. They're not stealing them off the cars anymore. That's another thing that's kind of weird. But what's really strange is they're stealing these plates, and then we've had some of the state officers say that they have to be sent to the federal government. So I'm assuming all of my plates are sitting in some evidence locker in the FBI or wherever. I've never gotten any phone calls. I've never gotten any emails from anybody. I've never gotten any investigators calling me. I've never gotten any federal agency calling me. The only contact, and it's not even a direct contact, that I've ever had with the federal government is when we were having if you go on my website and we go to the plates and passports page, and we go down to this link here, which is just a generic link that you can use to put a picture of your own nation here, and then you type your own nation name here. By the way, this is not for use for the Amnesty Coalition. If you use this and then just put Amnesty Coalition and put my logo here, you're not going to get any support from us. That's not how this works. This is for other nations to use as a template, because mine is going to have a $50 donation attached to it when I release it, which is going to be very, very soon, probably the next handful of days. But when I first started doing this, I used this Speedy signs, and I had the actual Department of State U.S. logo up here, which is the same logo they use on the ones that are issued from the Department of State. Uh-huh. The Department of State sent a cease and desist to Speedy signs, not to stop printing these plates, but only to not print these plates or any plates that have that logo on them.
Gotcha.
It was very specific. It wasn't you can't print diplomat plates. It was you can't put our logo on anything that you sell. And if you look at the code regarding it, it says that the seal can't be used for commercial purposes, I believe, something like that, right? Gotcha. So essentially what it was you're essentially commercially selling these things. You're commercially selling these things over state lines, thus it falls under the Commerce Clause. Via the Commerce Clause, we don't like it, don't do it.
Got it.
That's essentially what they were saying in English. So, but the thing is that, had they sent me a letter or an email just saying, hey, we don't want you to put, it doesn't even need to be a cease and desist. It could have just been, hey, we don't want you to put that logo on shit, on anything. Make your own logo or something like that. I would have done it. What do I give a fuck? So that cease and desist, that happened in like 2024, like early 2024. So I just stopped putting that logo on everything. I made my own totally custom Nation of the Amnesty Coalition Department of State logo. You can see it. I don't know where I would be able to show it to you, but it's somewhere. It's just the Amnesty Coalition crest. Mm-hmm. with a circle around it, and then in the circle it says the Amnesty Coalition around the top, and then it says something like Department of State along the bottom. And so I stuck that on there, and then we kept printing them, and then they wouldn't print them, and they said, no, remember I told you we can't print with the Department of State logo. I said, it's not the Department of State logo. I said, it's my Department of State logo. I changed it. And the lady, she had to look real close at it. And she goes, oh, yeah, okay. It's different than the one that the government makes. I go, yeah. And she goes, okay, no problem. And she started printing them again, right? But that's the only contact I've ever had regarding pretty much anything involving these plates is a cease and desist. That wasn't even to me. It was to fucking Speedy signs. So, it's like they treat my people and the ambassadors of my nation like they're murderers, and I've never even gotten a fucking phone call. Fucking weird. Crazy. But anyways, getting back into this writ of certiorari, unless you have something else you want to add or say there.
No, let's go.
So number 4, the U.S. citizen category was created by Congress to federally protect the freed Negro slaves in the slaughter. So this is, again, something I'd like to change just a little bit. I'm not going to, but it's one of those things I kind of learned later. So the U.S. citizen category was created by Congress to federally protect the freed Negro slaves in the 14th Amendment. And nobody really knew what the fuck was going on about any of that until the slaughterhouse cases. That's really a better way of saying this. Mr. Samuel Freeman Miller, while teaching himself law as a doctor, swore himself to the freeing of the Negroes and the ending of slavery. While obviously the entire Supreme Court was involved with the slaughterhouse cases, a cursory review of the history of Mr. Miller's past shows that over 2 decades of his life had been devoted to eventually freeing the enslaved Negro. The creation of the U.S. citizen category did not involve or include the free white people who were citizens of a state, as Mr. Miller makes clear in this quote from the slaughterhouse cases. He's talking about, we repeat then in the light of this recapitulation of events, almost too recently to be called history, but which are familiar to us all, and on the most casual examination of the language of these amendments, no one can fail to be impressed with the one pervading purpose found in them all, lying at the foundation of each, and without which none of them would have been even suggested. We mean the freedom of the slave race, the security and firm establishment of that freedom, and the protection of the newly made free man and citizen from the oppressions of those who had formerly exercised unlimited dominion over him. It is true that only the 15th Amendment in terms mentions the Negro by speaking of his color and his slavery, but it is just as true that each of the other articles was addressed to the grievances of that race and designed to remedy them as the 15th. He's referring to the 13th and the 14th Amendments.
Yep.
We do not say that anyone else but the Negro can share in this protection. Both the language and the spirit of these articles are to have their fair and just weight in any question of construction. Undoubtedly, while Negro slavery alone was in the mind of Congress, which proposed the 13th article, which means 13th Amendment, it forbids any other kind of slavery here or hereafter. If Mexican peonage or the Chinese coolie labor system shall develop slavery of the Mexican or Chinese race within our territory, this amendment may safely be trusted to make it void. And so if other rights are assailed by the states, which properly and necessarily fall within the protection of these articles, that protection will apply, though the party interested may not be of African descent. So he's saying other non-whites. His example is Chinese, which would be the yellows, and Mexicans, which would be the browns. None of this has anything to do with white people. He's saying other non-whites that would not qualify for state citizenship will also have the protections of the 14th Amendment. But what we do say, and what we wish to be understood, is that in any fair and just construction of any section or phrase of these amendments, it is necessary to look to the purpose which we have said was the pervading spirit of them all, the evil which they were designed to remedy, and the process of continued addition to the Constitution until that purpose was supposed to be accomplished as far as constitutional law can accomplish it. Now that's very fascinating, because he's saying that, like, we had to do this goofy, crazy, weirdo thing because we can't fucking violate the Constitution. So he's saying we did the best we could as far as constitutional law can accomplish it. And this is why I think this is so important, because people get so upset. Oh, the government's evil. Oh, the Supreme Court's evil. Dude, when you read this, you realize, like, these people cared so much about all this stuff. And Samuel Freeman Miller cared so much about the Negroes, and they were trying to figure this out, and it was so fucking complicated. And they were trying so hard they're like, no, we'll just create the second system, and then we'll give them a bunch of protections to protect them from the states. It's like when you hear the saying, the path to hell is paved with good intentions, you are looking into the heart and soul of that quote right here. This is the heart and soul of the path to hell is paved with good intentions. Okay?
I've never really liked that quote, to be honest, but I do have a question just from reading that. So the Naturalization Act, the most recent one at that time, was that still the 1802, or had there been a more recent one by
1802?
So once this 1868 14th Amendment passes, is that making, like, did that change the Naturalization Act? Like, would these Mexican and Chinese people, if they were to get naturalized, now they're being naturalized as a U.S. citizen rather than a state citizen after this act?
The Naturalization Act of the 14th, the Naturalization Act of U.S. citizens is essentially the 14th Amendment. The Bill of Rights of a 14th Amendment citizen is essentially the 14th Amendment.
But prior to the 14th Amendment, if someone was to naturalize, they would be naturalizing as a state citizen, right?
That's correct, under the 1802 Naturalization Act.
Right. So the 14th Amendment literally changed naturalization. as well.
It's split naturalization into two different categories and two different systems.
Right, but the naturalizing into a state citizen, nobody does that.
People were doing that up until the 1920s to 1930s. And then that's when, and it was petering out by that point. So by the early 1900s, it was pretty much petering entirely out.
Because now people, I mean, the entire naturalization movement is really about becoming a U.S. citizen. Now people don't even know this stuff about
That's
state
correct.
citizenship.
And the common law courts of record, which is where you have to go as per the Naturalization Act of 1802, are no longer exist. They need to be rebuilt.
That is the point I really wanted to get to. There really is no way to naturalize as a state citizenship as at this point.
There is and there isn't, because it's a unique situation. I talk about that in the very end, the bonus section in my treatise on the word person. So the federal government cannot confirm or deny state citizenship. And the state can't really confirm or deny state citizenship because there's no common law court of record. So you can't confirm or deny it on either end of the spectrum.
So why aren't immigrant? I mean, don't get me wrong, most of them just don't know. But for people who come into this knowledge, wouldn't they be able to use 42 USC 9102 subsection 18 to naturalize as a state citizen?
There is no federal statute that
because that's a
has
federal,
anything
that's a federal,
to do with state
statute.
citizenship.
Right.
So state citizenship would be done under 8 USC 1101 subsection A14, definition of a foreign state. It's considered California is a foreign state.
Gotcha.
And you can also see that under the definition of legal tender, which is 12 USC 50. I forget that one. I don't know how. I always forget that one. That's an important one. If you go to Google or something, here, I'll just, you'll see this very, very clearly. USC definition of legal tender. Yeah, 31 USC 5103. You also see it very clearly described here at the very end. Foreign gold and silver coins are not considered legal tender for debts. So they use the word foreign. And then if you go to 8 USC 1101 and you look at subsection A14, the term foreign state includes outlying possessions of a foreign state, but self-governing dominions or territories under mandate or trusteeship shall be regarded as separate foreign states. So California is a self-governing dominion, and
the unincorporated state of California.
Yeah, I'm trying to think if which one of these two the Nation of the Amnesty Coalition would be. The Nation of the Amnesty Coalition would probably be this one, but it may be this one. I don't know what their definition of territories is in title. Well, I don't like that term. That typically refers to something like Guam or Puerto Rico or the Virgin Islands. I would say this one here is probably a better. That's probably what the Nation of the Amnesty Coalition is. So if you go to the bottom of the website, you see right here, it's a foreign government as defined in 18 USC 11, and it's a foreign state as defined in A14. It's a self-governing dominion.
Right. As far as the naturalization aspect, though, the naturalization clause that you mentioned in your contract 2.0 course, the 42 USC 9102 subsection 18, why aren't these immigrants that are like getting detained by ICE using that?
The normal, well-to-do, well-assimilated, intelligent, high-income white person doesn't know anything about any of this. How is a fucking immigrant supposed to know anything about this?
Right. Would it even be effective if they tried it? Because I've argued with Grok about this, and Grok is like not a purist in the sense of like it says that it needs to be interpreted within the whole of the code basically, and that there's other restrictions and judicial.
Well, first and foremost, the only reason that immigrants have any protections at all is because of that Player v. Roe case from like the mid 70s, I think it is, talking about how young illegal immigrant school children have the right to go to school under the 14th Amendment. That's the case that extended 14th Amendment rights and obligations to illegal aliens. So what happens is you have all these nonprofit groups that give free attorneys and stuff to these immigrants. That's really all the stuff that's going on. Or obviously they take on like a public defender or whatever it is, right? But there's a lot of nonprofit groups that do this too. So the immigrants are basically just sitting there and they don't have any clue of anything that's going on during the entire proceedings. But your typical white person who was born in fucking Texas also has no idea what's going on during all the proceedings. So I don't see how that's any different.
Yeah, I'm kind of interested to see if someone was to come across this information and tried to use that as their defense, what the response would be from the courts. It's pretty plain language.
Every single thing that I could talk about as regards to hypothetical is just totally pointless because there's nothing, there's not even any case ever, even if I looked 150 years ago, where you're going to find some of this stuff, any of this stuff really argued at all like this.
Yeah.
There's nothing even close.
Yeah.
There's nothing even in the same like galaxy as to like even one small section of my writ of certiorari. If you cut my writ of certiorari into like 100 pieces, I don't even think hardly even a couple of those pieces has ever even been brought up since 1776.
Or at the latest 1873 or whatever.
I mean, yeah, they were talking about this stuff in Dred Scott versus Sanford. They were talking about it in Slaughterhouse.
Right. Yeah.
They were talking about it in U.S. versus Cruikshank, and then they were talking about it in Wong Kim Ark, whatever the fuck it is, 1890. I haven't looked into that case. That's the one case I haven't dug too much into. I need to. It's just a very long case, and I haven't wanted to get into that one yet, but I will. So, yeah, it's just not... if you look at the incorporation doctrine, there's a ton of incorporations that occurred right around the apartheid in America. Massive. There's like probably 30% of everything on there happened right around the 1940s to the late 1960s. So you have a lot of incorporation occurring for the Negro class or non-white class during that time period, right? So, yeah, it's all very fascinating. It's all very fascinating. I mean, there's guys running around in the sovereignty space that call themselves civil rights advocates, civil rights attorneys, or civil rights specialists. Unbelievable. Unbelievable.
This thought just popped into my mind. How did those state courts just dissolve without people being like, "Hey, we need state courts"?
I don't know.
Yeah.
The common law courts of record, if you go on my treatise on the word person, there's a link to a Grok article that's fantastic, and it gives the whole timeline as to how those kind of petered out and why. Basically, the federal naturalization courts were more convenient. And people just, I guess, didn't know the difference, so they just went for what was more convenient. And
yeah, but it's not all about naturalization. What about the protections of state citizens?
Yeah. Well, the way that it's structured is a little bit weird because since California is considered a foreign state, it's sort of like that's their problem, not ours. But that's like not true, but that's kind of, I think, what maybe happened. I don't know.
How DC viewed it anyway.
It's a very, very pathetic, very un-American point of view, but I have a feeling that might be kind of part of. I just don't know. I don't know what. I mean, the Civil War, I think, is the most violent war we've ever had, or something. I don't know. It's a really terrible war. I think afterward, I think people were just willing to say or do anything to just fucking not have it happen again.
Right. Yeah.
Yeah. So I don't know, like, how much of that was. I don't know, like, what. That's why I like reading these old cases. It's the best. It's the best we have. We don't have anything better than that.
So it seems like it was, to me, based on just what I'm picking up on this conversation, and I'm obviously speculating here, but it seems to me as if like the activities that would have taken place in the state court just got folded up underneath these federal or incorporated courts, and most people didn't realize the magnitude of or the exactly what was happening when that happened.
Well, you see it in TM 2025. If you read the original TM 2025, he's talking about how, like, oh, we have the greatest country in the world. Everyone's equal. Anyone can become U.S. citizens. We all have the same rights under the 14th Amendment, blah, 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 blah. And I've never read anything with someone who, A, obviously loves America, the guy who wrote TM 2025. I mean, my God, there's very few people that have ever loved America as much as the guy who wrote that. And then there's not a whole lot of people who have done the extensive amount of research and collection that the guy who wrote TM 2025 did. So by 2025? 1928 when it was written, I think. By 1928, a guy with tremendous research who was literally in the military writing about citizenship had absolutely no clue that there even was or ever was or even could be anything like a state citizen. Didn't exist. So as far as I'm concerned, by the turn of the century, it was completely gone. But by 1920, it was really, really super ultra gone.
Yeah, I feel like that's the cost of convenience. I think people were just trading that convenient aspect of let's just put all of these activities under the incorporated courts, and then they lost the entire republic.
Yeah, we lost a lot more than the 9th and 10th Amendment, but I'm starting to make the 9th and 10th Amendment sort of like the poster child of the movement, of my movement, right?
Right.
There's more to it, obviously. But the difference between a citizen and a sovereign citizen is the 9th and 10th Amendment.
Yeah.
You can have all the first 8 amendments incorporated. It wouldn't make you a sovereign citizen. You got to have that 9th and 10th to be a sovereign citizen. The 9th and 10th is sovereignty. I mean, you could almost, I don't really mean this, you could almost change or get rid of a lot of the other ones and just have the 9th and 10th. They didn't want to do that. They wanted to be more explicit, but I'm just saying the 9th and 10th it's everything.
Comprehensive. Yeah.
So it just leaves the door open for literally everything. Everything you want. Everything you've ever wanted, brother. Like if I translated the 9th Amendment in English, it's just whatever you want is yours as long as you have to be part of grand juries. You have to support the system, support the Constitution. Anyone harming the Constitution, destroying the Constitution, belittling the Constitution, acting treasonous toward the Constitution, they have to die. There's no question about it. As long as you do that, and as long as you're white, and as long as you don't hurt anyone, you can do literally whatever the fuck you want. That's the 9th Amendment in English.
Yeah. If it's not explicitly prohibited in the rest of the Constitution, it's fair game.
Well, the Constitution prohibits the federal government, so it's also kind of fascinating because it's not really prohibiting you to do anything. So it wouldn't have anything to do with anything else in the Constitution. The 9th Amendment is literally, you can, as a white man, as long as you support the Constitution and as long as you do the activities that are needed to make this thing work, to make the republic work, which is essentially the grand jury system. As long as you're willing to be a grand juror and you actually do it. And that's pretty much it. That is like, it's like a work visa program. Like you can be a part of our club and you give you an infinite freedom, but in exchange, you have to help us make sure that the system continues into the future. you're basically being invited in as a trustee of the Constitution, essentially. That's basically, and there's an exchange there. If you help us be a trustee and keep this thing going, essentially through the common law courts of record, the county recorder's office, and the grand jury system, that's pretty much the whole system in a nutshell. As long as you help us have those things and operate those things and do those things as needed, you don't need to work for the county recorder necessarily, but you definitely need to be able to operate on a grand jury. That's everyone's obligation as a citizen of a state. As long as you're willing to do that, then you get tremendous benefits. The exchange is extraordinary. It's like getting a Bugatti for $2. That's the way I look at it. If someone offered you a Bugatti for $2, it'd be hours and hours and hours of, this is a scam, I don't believe it, this is horseshit, blah blah, and then finally it'd be like, all right, fuck it, what do I have to lose here? Here's $2, and he gives him the key to a Bugatti and a fucking MCO right there live, and it's like, holy fuck. And then he's just in like a daze for like 2 days. Like, I can't believe I just bought a fucking Bugatti for $2. Like, what do I even do with myself? Like, to me, that's the level of what you're getting with state citizenship.
Yeah, now we just need to reinstall the court system to help enforce those protections.
So here's number 5. I'm kind of walking through a timeline on this, right? As you can see, obviously. The U.S. citizen category under the 14th Amendment was expanded to include legal fictions in first the Dictionary Act of 1871, found today at 1 U.S.C. 1, then was fully solidified in Santa Clara County v. Southern Pacific Railroad Company in 1886. Here is the exact quote from the case. And then you see this. This is a little footnote, and then you see this quote from the Chief Justice. The court does not wish to hear argument on the question whether the provision in the 14th Amendment to the Constitution, which forbids a state to deny to any person within its jurisdiction the equal protection of the laws, applies to these corporations. We are all of the opinion that it does. So it's kind of a weird thing. It's almost like a footnote. Like, you could almost argue, is this like really a footnote? Because they're saying that we do not wish to hear argument. So it's like, if it was never really argued, then is it even really part of the opinion, or is this more of like a side note? Like, does this really have the force of law? No one's ever brought up that. No one's ever brought up that as a claim. I've never even brought that up. I started thinking about that recently. I was like, wait a second. They don't want to hear argument, so that means, was it ever argued? And if it was never argued, then technically this isn't really part of the opinion. So technically it's not law judicially. It's just an interesting conversation that I've realized recently might be deeper than I had originally suspected. But anyways, number 6. Since this time, all non-whites, persons, slave trade clause, residing in the District of Columbia or U.S. territory / insular possession, and legal fictions have all fallen into the U.S. citizen 14th Amendment federal class of citizenship. This never included white people, preamble, we the people, who were citizens of their respective state. Mr. Miller does a great job in showing and describing how state citizens have no right to the 14th Amendment in Bradwell v. State, which is the next day after Slaughterhouse, where the Supreme Court had to deal, and when I say deal, I mean she was being a fucking retard, deal with a white woman who had an original domiciliary state, was also a resident, meaning not a citizen of that state, of another state, while also exclaiming that she was a U.S. citizen. Mr. Miller set her straight in his final opinion by letting her know that a citizen of a state has no right to the 14th Amendment at all in this quote. Quote, as regards the provision of the Constitution that citizens of each state shall be entitled to all of the privileges and immunities of citizens in the several states, the plaintiff in her affidavit has stated very clearly a case to which it is inapplicable. The protection designed by that clause, meaning the 14th Amendment, as has been repeatedly held, has no application to a citizen of the state whose laws are complained of. If the plaintiff was a citizen of the state of Illinois, that provision of the Constitution, meaning the 14th Amendment, gave her no protection against its courts or its legislation. Very fascinating.
Now, but
what that means in English is state citizens can't have driver's licenses.
Mm-hmm.
It's illegal. Literally unconstitutional and illegal for a citizen of a state to try to have protections or privileges under the 14th Amendment. The driver's license is the 14th Amendment protection or privilege.
Isn't the Social Security number as well?
Correct. But the Social Security number, if you look in the codes, it's very clear as to what classes can have a Social Security number. State citizens aren't on there at all. It's legally impossible for a state citizen to even acquire a Social Security number.
What about the birth certificate?
So I believe, since there's two of them. You have the certificate of live birth, and then you have the birth certificate. That's like the short form and the long form. They say short form and long form. I used to say that too. I'm not so sure, but I believe the long form is for you and the short form is for the sole proprietorship.
Mm-hmm.
But I'm not entirely sure about all of that, and no courts will even talk about any of it at all.
No. The only person I've seen have even a drop of success with it is this guy Govinda Tidball that was on the way forward with Alex Zek. And he's got them basically in fraud, mail fraud. I would just have to refer you to that because I don't want to mess up speaking on it.
The birth certificate thing, I've gotten away from it. I don't see it as relevant. You have a birthday and the sole prop has a birthday and you are not the sole prop. The sole prop's a 14th Amendment U.S. citizen. And if you're white, you are not. That's it. The birth certificate's irrelevant. Because you would need a birth certificate for what? To get a passport? The passport's only for citizens of the United States or people who, though not a citizen of the United States, owe permanent allegiance to the United States. There's only one class that fits into that second category, which is the non-citizen national of the United States, which is a statutory class that was created in the Immigration and Nationality Act of 1952. It's got nothing to do with the Republic. It is literally essentially a treaty class that's entirely under Congress. I was completely wrong about it. The whole movement is completely wrong about the non-citizen national class. It's nothing even remotely close to what I thought it was. It is essentially a special treaty class that was basically developed in the INA in 1952 because the people of American Samoa are terrified of the 14th Amendment because they feel like the equal protection clause of the 14th Amendment, if that got activated in their country, it would destroy their culture because they have like these Indian classes and they have these Matai, they're called Matai classes, where basically it's like tribes have like certain ways in which they pass like certain possessions. Land is considered very, very sacred. If the 14th Amendment activated in American Samoa, it would wipe all that out because everyone would sue each other and say, oh, the Matai class can't exist anymore. And they would basically, the Matai class would be destroyed through the courts in like literally like a few years, basically. So it's funny that the American Samoans are smart enough to know that the 14th Amendment is the devil's work and they don't want to have any part of it. The 14th Amendment is specifically why they did not want to be citizens of the United States, and they created a special treaty, statutory treaty, that was part of the INA in 1952, and that's what created the non-citizen national of the United States. I did all that research as part of my book, so I didn't understand all of that until I wrote my book. And then I said, God damn it, I'm going to have to really understand this better. So I did all the research, and I put it all in the book, as you just saw. Near the beginning of the book, actually, is where I cover all of that, right? So, yeah, the non-citizen national class is completely fucking irrelevant to, like, everything we're doing. And I was, like, totally, totally wrong about that.
Yeah. Yeah. You did spark my memory though. He's not challenging his birth certificate. His son was born and he had taken all of the proper procedure to not have them issue a birth certificate for his son, and they still did. And he's taken all of the like procedural, followed everything properly, and they're not responding to like his registered or certified mail. So like you're saying, you're not getting anywhere with it per se. But I would, as someone that is into this stuff, I know you've been on Alex Zech's show yourself.
I saw the Govinder
Govinder.
podcast.
Yeah, yeah,
The guy is extremely articulate. I mean,
right.
extremely well spoken and well put together. I mean, I love the way he talks. I just don't necessarily. I'm just not a fan of what he. I don't. Who cares? That's kind of my. I don't. They're not making a birth certificate about your son at all. It's completely irrelevant. It's just the sole proprietorship. That's all. They're just trying to create the sole proprietorship, and the birth certificate's for the sole prop. I don't. And you could say, well, if they made two, one of them is. It's just. It doesn't even. It doesn't have any real effect. If I had a son and they made a BC for him, let's say, I don't know, how does that affect him at all? It doesn't. It doesn't affect him at all. It has no relevance to anything. I just don't. They say, oh, the BC is the slave thing and it locks you into the system. Like, no, it doesn't. No, it doesn't. Because they're going to say, oh, it's proof that you're a U.S. citizen. That's the part. That's a rebuttable presumption. Whoa, hold on a second. The certificate says that I was born in Indiana. I'm white as fuck. How in the fuck was I born a U.S. citizen? That's the most insane, most ridiculous, most fucking faggot, pathetic thing I've ever heard in my entire fucking life. In fact, the birth certificate is actually evidence that I'm a state citizen. It's evidence that I was born in Indiana.
Right. Okay.
I would like to submit to the to court evidence of my skin color, Your Honor. My skin color is extremely fucking ghosty, pasty white. I'd like to put it into the record and indicate into evidence that I'm white as fuck, Your Honor. And then he'd turn to the defense or whoever. He'd say, do you have any objection to me putting into evidence that the guy's white as fuck? Well, no, I don't. Great. Now it's an evidence that I'm white as fuck. And plus, even if it wasn't, I'll stand in front of the jury. I'll just stand in front of them. Look how fucking white I am. Here's evidence that I was born in Indiana. Look at my skin. It doesn't say on the birth certificate that you're a U.S. citizen, I don't think. It has nothing on there about U.S. citizen. In fact, it says state of Indiana. So really, as far as I'm concerned, the birth certificate is proof of state citizenship. I have no problem with the BC. And the idea that there's a second BC, it's for the sole prop. Okay. Who cares? I got a sole prop. You're not going to get rid of the sole prop. I just don't. But even if you could or would, I mean, you when you understand your relationship with the sole prop does nothing more than just benefit you. That's the whole point of it.
Right. I was just about to say leverage it for your benefit.
So if the sole prop was originally developed as essentially a trust, it's a business, but it operates like a trust. And that's where people get really confused. They see a Sesta KV trust and all this. I don't like any of that, because if you start talking like that and you go into court, they're going to force a bar card on you. Oh, a trust, huh? Oh, you got a trust? Oh, okay. Well, in order to bring a trust into the courtroom, you have to have a bar card. I've seen it millions of times, and I've learned the hard way that that's not going to work. And that's when I started to develop, look at other options, and that's when I started to realize that sole prop. And then I was like, wait a second, if I say sole prop, they don't have a problem with it in the courts. They don't make you have a bar card. And I went, that's it.
Yeah.
So sole prop is the secret. That's the gateway.
Because it's individual prop, and then they just shortened that to individual, and you made the connection between individual and sole prop.
And there's this really shitty. I mean, I'll tell you what. There's very little case law that I disagree with. Like literally, I've never very hardly ever read case law that I was like, this is horseshit. Almost never. One of the only things I've ever read case law wise complete horseshit is this whole the owner of the sole prop and the sole prop are considered the same person. And I've looked up a few of the cases on that. There's only like one or two, and they're lower level cases. So they're persuasive authority. They're not really like appellate level case law. So this whole like you and the sole prop are the same thing. It's this like paper thin rebuttable presumption. And no one's ever rebutted it.
Right. Yeah.
But I'm telling you, it is paper thin. So what did I do? All my shit, even in this, you're going to see it. Well, have you already seen it? But you're going to see it again at the end. There's a split.
Right.
I'm the white Californian, and then you have the U.S. citizen sole proprietorship. No one's had a problem with it. And then think about this. They've had this thing for 5 months. When I called the company that I hired to get this thing, to get help with this thing, get it filed, they were like blown away. They're like, we've never seen this. We've been doing this for 15 years. We've never seen, or hardly ever seen anything like this, right? What I think happened is there's so much weird, crazy, goofy shit all over the writ of certiorari. For example, we got this guy, he's saying he's a white citizen of California. He's representing a sole proprietorship, but in order to represent another entity, you have to have a bar card, but there's case law that you don't have to do it with the sole prop. But I think that they kind of had to try to like figure all of that out. That's why they had the writ for so long, because when they sent it back to me, they had to list every single thing that was wrong with it. And I got about a half an hour before I signed up for the company that was going to help us get to the Supreme Court. I got this in the mail. I don't know if you saw my post on it. The Supreme Court sent me everything back in a box, and they sent me this. And the only thing wrong with it is the text of the appendix must be typeset in Century Family 12-point type with 2 or more leading between lines. The typeface and footnotes must be 10-point or larger. That's it. This is the only critique they had on the entire submission. Just that alone is humongous. Yeah. Just that alone is humongous. I could almost take this into a court of law as circumstantial evidence that I am not the sole prop. And I can bring the sole prop into court, and there's not a fucking thing you can do about it, motherfucker. Because if it was a problem, the Supreme Court would have told me about it. And they had the motherfucking thing for 5 fucking months. Who knows who they were showing it to? Maybe it was so complicated and they've never seen anything like it. Maybe they actually did have to go to the Supreme Court justices and say, sir, I'm sorry to bother you, but I have a submission that's so out of the ordinary that I need professional help. It might have gone that far because they had the fucking thing for 5 months. So what if some upper level, lower level attorney, or what if one of the Supreme Court justices has already looked this over? Somebody looked it over. They had to take it to some upper. This is not a normal submission. They get 7,000 to 8,000 submissions per year. This is very, very obviously a very unique submission. There's probably nothing like it they've ever seen. So they had it for 5 months because they weren't sure on a few things. They had to double check. They had to check some things, and they only had one issue: the formatting of the text of the appendix. That's it. That's the only. Congratulations. Everything about everything you submitted is perfectly fine, except literally just the formatting of one section, only the appendix. Not even the formatting of the main body. Just the formatting of the appendix. That's it. That's the only issue. Huge. Kindly correct the petition, but they didn't say anything's wrong with the petition, so I'm not going to correct that. And appendix, so that it complies with the above. So they're sitting around being like, what the fuck is this? Getting it double checked. Everyone's in fucking losing their mind. And then when I got the box back, I'll tell you this. This is another interesting point about this. A lot of black people work at the Supreme Court. I think almost every person I've talked to was black. So when I got everything back in the box, it was literally like, fuck you. Like somebody had taken it and just like crushed it all together and like thrown it. It was all fucked up. So there's, I think, a lot of black people work there. And I think this writ may have fucking been like a bit of a grenade getting thrown in there. Mm-hmm. So like you have however many justices in the Supreme Court, I think 2 of them are black. You have Clarence Thomas is male, and then you have a female black justice. I forget her name. But I'm talking about the people who work there.
Right. Yeah.
A lot of black people. From my experience, a lot of black people work at the Supreme Court. So is it possible that they like freaked out or who knows? But I'll tell you right now, this, as far as I'm concerned, this is evidence that my theories about the sole prop are true. Because if not, they would have mentioned that. If not, they would have mentioned it precisely. Right. Yeah. Because there's literally in the Supreme Court rules, it talks about how you can only represent yourself. If you're representing someone else, you have to have an attorney who's a member of the bar of this court. On the website of the Supreme Court, they have a link how to become a member of the bar of this court. So it's a whole thing. So they would have said that, and they would have referenced that rule in this document if it was a problem.
Yep.
Humongous. It's going to cost me, by the time I'm done going to the Supreme Court, so I've spent several $100s already, and then I just signed a contract for $3,100 to get help. To get help.
To get it.
So by the time this thing's all said and done, it'll probably be about $4,000 into it. But considering up to this point, it was $405 for the initial case and then $605 for the appeal. So that's another $1,000. So it's about $5,000 from the ground floor all the way to the Supreme Court. But that's stretched out over years. I think the first case was filed in 24. I want to say April or May of 24. So we're rounding around 2 years. So $5,000 in 2 years. And the only reason why it was so short of a timeline is because the appeals on this case was like 5 seconds long. It was like I filed something in, they filed something in, and the court was like, absolutely not, fuck you, and did summary judgment. So the appellate procedure on this case was like 5 seconds long, literally. It was like hi, bye. That was the appellate. So I would say normally you're looking at a longer. Like if you look at my Amex case, it's a much. I mean, we've been in that case for a while now, like many months or maybe over a year. So let's say 3 years to go from the bottom to the top. So it's $5,000 over 3 years. That's but a majority of that cost is all the Supreme Court stuff. The problem with the Supreme Court stuff is you can print your own booklets, maybe spend about $500, $400 to print your own booklets and send everything in, but then. If you're like me, you're waiting and waiting and waiting for God knows how many months, or calling. You can't get a hold of anybody. You end up resending it. It's stressful. The stress alone is not worth the money. I'm paying the $3,000 just because, dude, this has been like really stressful. This has been the most stressful thing like I've ever done in terms of like trying to get things to work and trying to get things docketed and trying to understand. I can't get a hold of anybody, and there's not that much information on the internet about going to the Supreme Court. There's very little information anywhere. Even AI struggled to find me anything about literally anything. And the clerk's office just kind of treated me like shit. they just kind of, I don't know, not really, but like kind of. And like I tried to have like really good notes. And I tried to be like super fast and streamlined. And I told them on the phone, hey, don't want to waste your time. I got some questions here about, and they're just very like dismissive. I don't know. Just the Supreme Court has not been a good experience, frankly. So I'm paying the $3,000 to just, I went for it myself. I gave everything I had. I read all the fucking rules. I did everything by hand. Fucking rulers. I had rulers. I put tape over the staples.
Yeah.
Because the rules say that if you do staples, you have to put fucking scotch tape over this. So I'm sitting there. I bought scotch tape. I mean, just formatting, printing, and following the rules took like a month of horseshit and work. And it because my appendix, so 8 million things I could have had wrong. I got everything right except the formatting of the appendix. So I was almost there. I was on the 99-yard line. But because one thing was wrong, 5 months of what the hell happened, 5 months of calling and no one answering. I spent whatever I spent on resubmitting it. It's the stress really that's not worth the money to me. That's really what it is. It's the stress, right? So had I known, well, no, even if I would have known, I'm glad I did it because I am confident now. I know how to go to the Supreme Court even without help. If I really, really had to, I would next time just be more careful about the appendix. That's it. That's how close I got to the 99-yard line and didn't make it. But what I did get is certainty that I can go to the Supreme Court without help. And I learned a lot in the process, and it's something that I'm glad that I did, but I probably won't do again. I'll probably hire, if these guys work and it's a good experience, I'll probably continue to use them for future submissions. So, yeah. With that said, let's get back on this here. So, state citizens can't use 14th Amendment, right? That's the quote. 7, the white people's, not persons, state citizenship class has fallen out of view over the years. This has also been complicated by the fact that everyone has a sole proprietorship and has a hard time determining the difference between themselves and their business that has the same name that they do. This has contributed to the confusion regarding sovereign immunity. Also, it is confusing that the sole proprietorship falls under the 14th Amendment, while a white citizen of a state does not. In fact, if a white state citizen says they are a U.S. citizen, they risk a felony violation of 18 U.S.C. 911, which isn't necessarily true, by the way. I always say that. It's actually not technically true, because if you look at the general provisions of Title 18 and you look up the definition of United States, it's referring to it wouldn't include places like California and stuff like that. So, and then also the definition of a person, obviously in Title 18, is referring to any man, woman, child, or legal fiction that has rights and privileges under the 14th Amendment. So technically, the 9th and 10th Amendment would give me immunity to an 18 U.S.C. 911 charge, but that's a very, very complicated. It's cool to say, and it gets people to think, and it gets the gears kind of going when you say it like this.
Right, but the 9th Amendment would.
The 9th Amendment, if they charge me, they can't charge me with an 18 U.S.C. 911, technically. But I didn't really know that until recently. But I still continue to say all of the stuff I used to say because I think it's good. It's you could say it's a lie, but they can charge me with whatever they want. They can charge me with everything. They could charge me with, made up shit. They could charges just means they're alleging something. Allege just means they're bringing forth that of which they intend to prove. So being charged with an 18 U.S.C. 901 means we say and intend to prove that we have a legal basis for an 18 U.S.C. 901 charge. And then at that point, I'd be like, ha, 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 9th Amendment, ha, 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 definition of United States, ha, 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 definition of a person, goodbye. So Just being charged, though, would be a nightmare. So technically what I'm saying is true.
Yeah, they risk a felony violation. I mean, you technically do risk
technically you risk the violation and the charging, but it's just so funny. It's like they say sovereign immunity, but it's like we actually are the ones who have the sovereign immunity. That's the funny part about it. That's the part that's it's just totally flipped. Everything is flipped, right? So here's where I get into that. Moving on to the subject of sovereign immunity. So in this case, the American hero, Justice John Marshall, says the following, showing clearly that sovereign immunity for a corporation is impossible. It is, we think, a sound principle that when a government becomes a partner in any trading company, it divests itself, so far as concerns the transactions of that company, of its sovereign character and takes that of a private citizen. Instead of communicating to the company its privileges and prerogatives, it descends to a level with those with whom it associates itself and takes the character which belongs to its associates and to the business which is to be transacted. Thus, many states of this union who have an interest in banks are not suable even in their own courts, yet they never exempt the corporation from being sued. The state of Georgia, by giving to the bank the capacity to sue and be sued, voluntarily strips itself of its sovereign character so far as respects the transactions of the bank and waives all the privileges of that character. As a member of a corporation, a government never exercises its sovereignty. It acts merely as a corporator and exercises no other power in the management of the affairs of the corporation than are expressly given by the incorporating act. Pretty fucking wild. You hear about this a lot in the sovereignty space. Oh, this and that, and this and that. But this is the actual case. This is the actual quote that comes from. Right? That's the problem. People go into the courts, they pair it off the same horseshit. There's no basis for it. I do the polar opposite. I don't tell you shit. I just have a teeny little blurb and I go, I don't need to say a fucking word. John Marshall is going to do everything for me. Here's John Marshall. It's like I'm like a radio broadcaster. Oh, you're going to love this next song. It's Goo Goo Dolls. Their hit single, blah, 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 blah. Then I just put the Goo Goo Dolls on. I'm not going to tell you all about the Goo Goo Dolls. Just put it on the radio. That's how I do it. That's how you're supposed to do it, you see? And that's what very few people are doing in the sovereignty space. That's why people lose. I used to do that too. And then I learned my lesson, right? Number 9, looking at the definition of a person in 8 U.S.C. 1101 subsection B3, we have the definition of, quote, an individual or an organization, end quote. Then, looking up the definition of organization in 8 U.S.C. 1101 subsection A28, we have, quote, the term organization means, but is not limited to, an organization, corporation, company, partnership, association, trust, foundation, or fund, and includes a group of persons, whether or not incorporated, permanently or temporarily associated together with joint action on any subject or subjects, end quote. Number 10. Comparing the above to 8 U.S.C. 1401A, which is the definition of a U.S. citizen or U.S. national, somebody who's born having both U.S. nationality and U.S. citizenship. A person who was born in the United States and subject to the jurisdiction is a U.S. national and U.S. citizen. This includes, quote, organizations, end quote. See, I'm building it up. Number 11. If the United States Small Business Administration is a organization, quote unquote, in accordance with 8 U.S.C. 1101 subsection A28, and is a U.S. citizen in accordance with 8 U.S.C. 1401A, then it becomes an absolute physical and legal impossibility that it has sovereign immunity. The U.S. citizen class is a class that was originally created by Congress in an attempt to protect the released Negroes who were being abused in sick and vile ways by the states. Then, for some odd reason, legal fictions were added into that same 14th Amendment citizen pot. This has caused massive confusion ever since. 12. Any corporation that the sovereign body called the United States creates would be, by definition, a U.S. citizen. That U.S. citizen does not enjoy any sort of immunity and wouldn't need to, which matches perfectly with the quote from the Honorable John Marshall above. Federal Reserve notes are simply just promissory notes, unconditional promises to pay in accordance with UCC 3-104, and the government can print all the U.S. currency notes they want in accordance with 31 U.S.C. 5115. So the petitioner, meaning the sole prop, nor his owner, meaning me, can harm the SBA or United States, defined in 4 U.S.C. 71 as meaning the District of Columbia, by taking Federal Reserve notes from the SBA in a judgment. All the U.S. Reserve notes, all of the U.S. currency notes produced can be swapped at the Federal Reserve discount window for Federal Reserve notes as desired in accordance with 12 U.S.C. 412. So any idea that sovereign immunity applies to financially protect the United States or to financially protect the SBA is irrelevant. Even if the petitioner took trillions from the SBA in a judgment, all that would do is inflate the value of a Federal Reserve note, but it would not financially endanger the government or the SBA in any way. Which is totally true.
Yeah.
Number 13, it is also crystal clear in 15 U.S.C. 634B1. This is the general provisions for the charter for the U.S. Small Business Administration. It says there that the SBA may, quote, sue and be sued in any court of record of a state having general jurisdiction or in any United States district court, which means federal court, end quote. But that gets interesting because technically what they're saying there is it can be sue and be sued in any court of record of any U.S. territory or insert possession or in any federal U.S. district court. That's actually what they're saying, because the definition of the word state in federal statute is only referring to areas under the exclusive control of Congress. So when they say any court of record of a state, they're not talking about California. But state of California is a U.S. citizen. So, so the question becomes: Would state of California fall under the definition of this definition of the word state? Technically, right. Yes, but they're not referring to a state of California that is under the Constitution, and they're not referring to state of California, which is under the 10th Amendment. They're referring to a corporation which is a U.S. citizen that's called State of California, which would actually be a 14th Amendment U.S. citizen and would not have any 10th Amendment rights at all whatsoever. And that's what's so fascinating, because police powers, the entire police force, is based upon the presumption that State of California has 10th Amendment powers. And it doesn't at all.
No kidding.
So if you pulled the 10th Amendment from State of California, the entire police force of every single area, all police, the entire, even the word police would literally instantly vanish off the entire nation. It'd be gone instantly. If someone brought that in and proved that and pushed that all the way, they would destroy the entire police force nationally. The State of California does not have any rights under the 10th Amendment at all whatsoever. It's not a state, as per the definition, as covered in the 1805 case with John Marshall. Number 14. This quote from 19 Corpus Juris Secundum, section 883, also helps to clarify the situation. Quote, the United States government is a foreign corporation with respect to a state, end quote. They say it themselves. The definition of a foreign state: foreign gold and silver coin will not be considered legal tender. They say California is foreign. So why wouldn't United States be foreign from us? They say we're foreign. So if I say they're foreign from us, we're saying the same thing.
Yeah.
We're saying the same fucking thing, guys. 31 U.S.C. 5103, definition of legal tender. We're saying the same thing, guys. You guys say foreign gold and silver coin is not considered legal tender under Congress. Hello, I'm over here. Foreign, what do you mean foreign? You mean the states? So you're saying Article 1, Section 10 doesn't apply? You're right, but the 10th Amendment doesn't either, bitch. 10th Amendment protects the state as defined in the Constitution. So if that's the case, if state of California supposedly has police powers under the 10th Amendment, at the same time, state of California would have to only use gold and silver coin as a tender in payment of debts under Article 1, Section 10. So they don't want this over here. Oh, no, that doesn't apply to us. But we have 10th Amendment rights. No, bitch. No, bitch. You can't not comply with this part of the Constitution because it doesn't fit your fucking bullshit, and then and then say you have rights over here. That's bullshit. Oh, no problem. You have 10th Amendment rights? Oh yeah, no problem. Now, if you have 10th Amendment rights, Gavin Newsom instantaneously is no longer your governor, because Gavin Newsom is a U.S. citizen. So if you guys are a state under the 10th Amendment, you better get your act together, because I'm going to pull your charter. I'm going to do a writ of quo rento. I'm going to pull your whole fucking charter if you guys don't. You guys need to get on the gold and silver coin standard under Article 1, Section 10. You've got 30 days. Otherwise, I'm filing for writ of quo rento. I'm going to pull your whole charter. And also, Gavin Newsom, you gotta put out a thing or whatever. He's no longer the governor. He's a U.S. citizen. You can't be the governor of California. So go ahead. Now you got your police powers. Congratulations. But you can't have it both ways. If you do this, then you have to have the Article 1, Section 10 gold and silver is the only thing that can be a tender in payment of debts. And just the problem is no one's ever brought any of this into a court. And if they did, it was done very poorly. Very, very poorly. I mean, like you want to cry poorly. And the bigger problem is the very, 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 very few people that I have seen who have brought any of this stuff into court. They bring it in very poorly, but then they never continue. It's like, okay, I've brought a lot of shit into the courts poorly too. I started in 2024. But I kept going and I kept going and I kept learning and I figured out why, and I went to appeals and I fixed my shit. And now here I am 2 years later, and I'm starting to get pretty good at some of this stuff. I'm starting to get somewhere. And I'm willing to continue to do that over and over and over again as long as it takes to get to where I need to go. And that's the part. It's like, gosh, the few people that I have seen, they've put so much work into getting to, let's say the 20-yard line, let's say the 40-yard line. And they just die there. They just die there's very few people who even make it to the 40-yard line, but the death rate at the 40-yard line is extremely high. Most people never even go to appeals, for Christ's sake. I mean, to me, it's like, oh my God, you don't even go to appeals? Like, holy shit. Like, I see that the Supreme Court thing is tough. This is the first time I've been seriously challenged, this Supreme Court thing. I mean, this is really challenging, right? But appeals? Oh, God. Especially in the Ninth Circuit. I mean, God, it's easier to go to the Ninth Circuit Court of Appeals than it is to file a fucking district case. I am dead serious. There is no excuse for not going to appeals in the Ninth Circuit. They give you an informal Word file. You download it, you just plug shit into it, and you upload it to an extremely simple, friendly login system. I mean, we're talking, it's the only court, as far as I'm concerned, that gets it, that has put any effort into trying to make it accessible for pro se litigants. And they make the other guys send papers. If you look at the docket, it says, defendant, American Express, submitted electronic answering brief, and they have like 30 or 60 days to send a whole fuck ton of paper, whatever, under blah, blah, blah rule. And then you'll see like a week later or whatever, it'll say paper requirements received by court, blah, blah, blah. So they have all to do all the shit, and they have to do it like all these rules and all this margin. I mean, to them, it's like normal. Like they've done it a million times. So they just like copied the last time they did it, and then it's all set up. But I'm just saying, like, the Ninth Circuit makes it really, 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 really easy for us. The only real downside is the cost. It's $605 to go to the Ninth Circuit. So I understand that it can be a bit cost prohibitive, but I get a little irritated when you have someone who hasn't even tried to go to the appeals. They haven't even tried to do a in propria.
Persona, yeah.
No, in propria. What's the? You don't have any money.
The pauper.
Pauperous. In propria pauperous. They call it an IPP. They actually have a thing for IPP, right? IPP. So I don't even see them filing that. It's like, at least file that. And then if they deny the IPP petition, fine. But I don't even see that. And that's when I'm like, cool, you got to the 40-yard line, but like, there's a part of me that's kind of like, fuck you. Like, if you believed in any of the shit that you said here at the lower court and you got to the 40-yard line, you obviously don't believe in it that much.
Yeah.
Because why wouldn't you? I can see now. I can see the Supreme Court thing. That's a hell of a jump. Jesus, the Supreme Court thing has been rough. I can see. I have seriously thought about giving up on the Supreme Court a little bit. I hate to even admit that. To me, it's like blasphemous to even admit that. But it's been rough. Like I am beaten down to the point where I am willing to spend $3,100 to get assistance to get this done. Right? It has been soul crushing, and the reason why I can't get a hold of anybody, no one answers shit. They treat me like shit. It's awful. If the Supreme Court was a business, it would be gone so fucking fast. It would have so many fucking 1-star reviews. Holy shit. I mean, God, Yelp would be like, this place has got to go. There'd be like class action suits against it. It's awful. It's just awful, right? And the fact that sort of behavior and you might even think, oh, Brandon, you're being racist because you said they're all black, and no. This is just, I'm telling you, this is just, if they were all white as fucking snow, I would literally deport them. I'm telling you. Like, that's how fucking bad we're talking, dude.
Yeah. Well.
So it's one of those things where, it's not a very good representation of the highest court in our country. It's actually depressing, sad, and the people that are there should be fucking ashamed of themselves. That's the real truth of the matter. You know what I mean? But anyways, continuing with this number 14, this is exactly why the very first version of the Social Security card said employee's signature on the bottom right where they signed. They took that off real fucking fast. They took that off there, right? But you look at the very, very first version, it says employee's signature on the bottom right. So employee of what, right? That's the question, right? And then if you look at the definition of employee in the tax code, it's an employee of the federal government. So that's what they're talking about. That's really what they're talking about, right? So 15, this quote given by the Honorable Chief Justice Morrison Remick Mott Waite in United States versus Cruikshank helps clarify the above situation, but it should be taken with the knowledge that legal fictions had not been added in as persons under the 14th Amendment until 1886. We have in our political system a government of the United States and a government of each of the several states. Each of these governments is distinct from the others, and each has citizens of its own which owe it allegiance, and whose rights within its jurisdiction it must protect. The same person may be at the same time a citizen of the United States and a citizen of a state. Now, this is interesting because when bar cards say, oh, no, they have both, they're kind of loosely referring to this quote. But if you look at the wording of it, it says may be. So he's saying we have all these different governments and a person may voluntarily, if they so choose,
right,
be at the same time these two classes. But then you also have to keep in mind when they said this, legal fictions had not been added in as part of the definition of a citizen of the United States. So it was only men and women. It was a human term. And then it became a human/non-human hybrid term in 1886. So you got to be very careful with this quote. If you have those things in mind when you read this quote, it makes sense. It makes perfect sense. But his rights of citizenship under one of these governments will be different from those he has under the other. So if you understand all of that, and you understand state versus U.S. citizenship, and you understand that legal fictions hadn't been entered in yet, it actually makes pretty good sense. I think it's a bit silly because, why would they be both, and how would that work? And it's kind of like when you have a cop and you have professional official capacity and private capacity. I think that's kind of how it works. So it's like in each thing that you're doing, or in each contract, which capacity are you contracting under? If you are both of these things, state and federal citizen, then you have to be specific as to how you're contracting under each one. But I think at that time, maybe that's what he was trying to say, but that's not really functional in today's society at all. So it's a historical point that I don't think is really even translatable to today's world, because you have the sole prop, you have legal fictions being added in as persons, and then you have the sole prop. Those two things complicate and convolute everything very heavily, right? Number 16, this quote from the Honorable Clemente, I don't even know how to say it, I'm not going to try, in U.S. versus Valentine in 1968 shows with clarity what absolute rights the U.S. citizen class has prior to the incorporation doctrine infusing the white man's rights into the 14th Amendment class. Quote, the only absolute and unqualified right of a United States citizen is to residence within the territorial boundaries of the United States, end quote. It's rare that you see something that clear, that concise, that specific, and that just direct. It's very rare you see something so fucking solid, right? 17. You can see further clarity by this quote from the Civil Rights Act of 1866, now found in 42 U.S.C. 1981A. Bolds and underlines will be added to show attention. All persons within the jurisdiction of the United States shall have the same right in every state and territory to make and enforce contracts, to sue, be parties, give evidence, and to the full and equal benefit of all laws and proceedings for the security of persons and property, as is enjoyed by white citizens. Another excellent quote found right after the above is the next section, which is 1982. All citizens of the United States shall have the same right in every state and territory as is enjoyed by white citizens. Just that alone shows very clearly that there's entirely two different classes. They're talking about citizens of the United States, and then positioning that to another term called white citizens.
State citizens.
So by definition, by obvious process of elimination, you could have an IQ of 70 and figure this out. Obviously, whatever they're talking about in the earlier portion, which is citizens of the United States, wouldn't include, quote, white citizens. So what would it include? Well, originally it was for the Negro, but just like Mr. Miller said, it would also include Mexicans, Chinese, so you got the yellows, you got the browns. So what is it really? It's just non-whites. That's what it is. And I know my treatise on the word person says Negro, 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 and then sometimes it'll say non-white. It's a little confusing, and I know it's not like super nailed down, and the reason why that is because it's just, even in law, I just don't think it's very well nailed down, especially when translated in today's society. Even if you go back 150 years, I feel like it's very poorly nailed down. Then on top of that, you bring it to 2026, and dude, you don't have a chance in hell. Why even talk about that shit? It's not even the specifics of the racial aspects. It's just you're going beyond what is even translatable. You know, it's very simple. You got the whites and the non-whites. You got the states and the U.S. and that's it. That's pretty much, you know. And the core reasoning behind it is the Negroes. That's the core reasoning behind it, right? And then we have here the best and most clear place I have ever seen this described is in Eleanor Van Valkenburg versus Albert Brown. I'm sure you guys have seen this. I've talked about this on a million shows. This one is literally just crystal clear, where he's talking about how no white person born within the limits of the United States and subject to their jurisdiction or born without those limits and subsequently naturalized under their laws owes the status of citizenship to the recent amendments to the federal Constitution. He's referring to the 13th, 14th, and 15th Amendments. The history and aim of the 14th Amendment is well known, and the purpose had in, maybe at that time it was, and the purpose had in view in its adoption well understood. That purpose was to confer the status of citizenship upon a numerous class of persons domiciled within the limits of the United States, which could not be brought under the operation of the naturalization laws because native born and whose birth, though native, had at the same time left them without the status of citizenship. These persons were not white persons. They should have said people there. But were in the main persons of African descent who had been held in slavery in this country, or if having themselves never been held in slavery were the native-born descendants of slaves. Prior to the adoption of the 14th Amendment, it was settled that neither slaves nor those who had been such, nor the descendants of these, though native and freeborn, were capable of becoming citizens of the United States. And there it is, Dred Scott versus Sandford. And by the way, Dred Scott versus Sandford, out of the 9 justices that voted on Dred Scott versus Sandford, 7 of them voted for it. Only 2 dissented. So Dred Scott versus Sandford, people always point their finger at Taney because Taney's the one who gave the final opinion. It was almost clear across the board. It was voted yes for Dred Scott versus Sandford from the entire Supreme Court. There's only 2 dissenting arguments. So it wasn't just Taney. It was a vast majority of the entire court at that time, which is something I recently learned and added to the treatise on the word person like just a few days ago. The 13th Amendment, though conferring the boon, which means benefit, of freedom upon native-born persons of African blood, had yet left them under an insuperable, which means impossible to overcome, bar as to citizenship, and it was mainly to remedy this condition that the 14th Amendment was adopted. So that's like, you could take a bar card. This is like smashing them in the face with like an aluminum baseball bat. This one is just like, that's why I left it for the very end. It was like the killing blow. That's why I put it at the very end here, right? And then you have reasons for granting the petition. It's like just kind of recovering a lot of that, kind of in my own words or whatever. And then talking about the circuit split. And then talking about recent cases by circuit grossly misapplying this, and where the cases were removed from state court to federal court, but the original state court doesn't fit the definition of a state court from the statute. Just use AI, and I just typed in, give me a few cases from each circuit where like a case was removed from one of the states of that circuit and sent to federal court, and then I just double checked each case to make sure it was correct, and then I just put it on here. That's how I built these out. And then the conclusion is the petition for writ of certiorari should be granted. And then you have here Brennan Joe Williams, white Californian, owner and registered trademark holder of sole proprietorship and U.S. citizen, all caps Brennan Joe Williams registered trademark. And you can see that at the top as well. We have Brennan Joe Williams registered trademark petitioner. Petitioner is a sole proprietorship being presented pro se by owner. Petitioner is presenting pro se by owner. And that's the part that I know for a fact they had never seen anything like that, and they had to figure it out. And for all I know, it may have gone up as far as being seen by one of the justices. I have no idea. But they had the motherfucking thing for 5 months. So, and there you go. That's the writ of certiorari.
Oh, yeah.
So
Well,
it's got nothing to do with the original complaint, because the original complaint with the SBA was mostly about negotiable instrument. It has to do with all the horse shit that happened along the way. So it's like legal questions that you're asking the Supreme Court to look at that have to do with like procedure or structure or shit or transfer or some kind of like legal aspect. And what they want to see is they want to see circuit split, and they want to see that whatever questions you're asking have national importance or effect. Basically, that's what it is. So,
yeah, I hope the people that you're paying are able to get that pushed through for you.
it's not going to be an issue. They've been doing this for like 15 years. So, I have, and it's really just. They told me straight. It's almost always just. It really is just always formatting issues. That's really what everybody has issues with. So, and I can see why. I spent a fucking month trying to figure out just the formatting, and I still couldn't pull it off. So I understand that that's. And people are always saying like, "Oh man, they make it so hard." It's like, "Oh, well, it's like jump through all these hoops, blah blah." I think. So they get 7,000 to 8,000 of these things a year. They can only really see 1%. I think they make people jump through hoops and stuff like that because they don't want like complete idiots. Because if complete idiots could make it through the hoops, that 7,000 to 8,000 would become 90,000, and then the 1% would go to 1/50th of a percent.
Yeah.
And it would just make everything worse. Like, for example, if I was in the Supreme Court and I had a bunch of retards, I would put in stuff like what they have with all the formatting and stuff on purpose just to weed out people who have an IQ below like 100. I don't know if I'd make it quite as hard as it is, my God, but I see why they do that. You know.
Yeah.
I'm not mad about it. I'm not mad about it.
That's been a learning experience for you, I can tell, for sure.
I took a lot of the same formatting I learned from the Supreme Court, and I put a lot of that same formatting in my book because I in the rules and stuff, they explain why they use some of the formatting requirements. And so that's kind of interesting. Like they allow 3 fonts, and I checked all 3, and the one I liked the most was Century School Book, which you don't really see very often. And so that's why I use Century School Book in my book. That's the font in my book. So it had other implications by going through the hell of formatting everything for the Supreme Court. That, I mean, it's all good. I'll tell you right now, once you've climbed Mount Everest, every other fucking mountain's easy. So I'll tell you what, I've climbed Mount Everest with this formatting shit. So if I ever have any sort of formatting requirements or rule requirements or anything in the future, it's not going to be, I guarantee you, it's going to be easy peasy compared to this one. So now that I've done it, everything else is going to be, it's all downhill from here. So.
I gotcha. I am updated on the law stuff, but I did have a couple of just social issues. Just wanted to hear your thoughts on this Epstein file shit and this World War III shit.
The World War III shit, I don't even follow it. It just seems like trying to get people away from other shit. I think the sovereignty space is exploding. I think the Epstein, it just seems like they're just trying to, that just seems like a
mass distraction.
Yeah, and the support that America has with Israel is completely falling apart, and I think Israel realizes that
it's like one of the only things that both parties agree on. Well, like the people, not the actual politicians, but
I think Israel knows this is the last president they're going to get, and I think they're trying to squeeze every drop out of this presidency that they can, because I think that they realize that they're about ready. The train tracks are about ready to end. They've had a really long, really one-way relationship with the United States, and I think they can see it's coming to a screeching halt very soon.
Yep.
And I think they're just trying to push the gas pedal down to get every single drop out of this administration before the train tracks end forever, hopefully forever. You know, so anyways, so that's, you know, besides that, I don't care. I don't follow it. It's irrelevant. I just don't.
I don't either. I just wanted to hear what you thought about it.
I just think it's a false flag. I mean, Trump, I think a couple of days ago announced that he thinks it's already over. I mean, he is interesting in the fact that he kind of comes in and he does these like very, very specific strikes, like the Venezuela thing. It was like, it wasn't a war. It was like a 1-day ordeal. That's kind of interesting because typically, like in a lot of our previous administrations, it's like the purpose of a war is to start something that never ends.
Regime change and occupation, yeah.
Forever wars, right? Trump doesn't seem to be doing that. I don't hate Trump. I want to be specific. I'm not a big fan. I'm in a rare category that I don't think really exists. You don't meet people in my category very often where I'm somewhere in the middle and I kind of shift, but I'm kind of always in the middle, but sometimes I'll kind of shift over to like maybe I kind of like him a little bit and then I'll kind of shift more over to like not so much right now. And it's kind of like this floating kind of shifting, but it's always kind of somewhere in the middle. The 14th Amendment, birthright citizenship stuff. So if you remove the 14th Amendment birthright citizenship stuff from Trump's platform, it would send me pretty far into the not so thrilled category. But because I think that's so fucking huge and so important and so monstrous and like no one's ever fucking talked about this, that alone brings me like all the way up into like the center or like low positive. But if you remove that one piece, I go pretty heavily into the not so thrilled category. So, but I think that's just monstrous. And the fact that he's got Mr. Sauer, John Sauer, his Solicitor General, fucking literally in the Supreme. If you go on Wikipedia and you look up John Sauer, the Solicitor General of the United States, there's a little audio clip there. And that fucking audio clip is him in the Supreme Court, on the floor of the Supreme Court, talking about how the 14th Amendment was for the released black slaves and their children. Dead fucking serious. So I sent Mr. Sauer a free copy of my book with a cover letter thanking him for his work on the 14th Amendment stuff. So the fact that he's got his guy in there working on that as a high priority, that's really, to me, that's the most important thing that I see Trump doing. I don't think he's a bad guy. And you also got to think, you got to think about it relative to everybody we've had in the past. Is he better than pretty much every Republican president I've ever seen? Yeah, I'd say probably yeah. We're not seeing forever wars. That's kind of interesting. So it's like, oh, he's doing these wars, but they're fast. So if this Iran thing is wrapped up quick, it's just interesting. Have we ever really had? I don't know. I was so young, Desert Storm and all these. I was so young. I don't know, but it just seems like these things are on and then they're off real fast. So I don't. That's a fascinating. Would you call that a war? You know. I don't know. So it's a fascinating thing, but I just don't like the details and like what's happening. It's no, I don't.
Yeah, I personally find myself not liking him at all, but at the same time, the Trump derangement syndrome stuff kind of irks me as well, which is why, like, your stance doesn't bother me. And I've got a friend of mine that's probably definitely even more pro-Trump than you. And it's like, I can digest this stuff and actually have conversations with people about it, even if I disagree. The Trump derangement syndrome, where people are just freaking out if you say anything good about Trump, I don't like that. Even though I don't really like him at all and I don't find much good to say about him, I still don't find much. How are we benefiting from screaming at people who have any sort of find any sort of redeeming quality in the man? How is that?
Well, he pulled us out of like almost every 465 UN treaty agreements, which I thought that was fucking super badass.
Okay, no, I will say are specific issues. I agree.
But then he spun around and created this peace treaty thing, and he's like giving himself $1 billion to run that. It's one of those things where it's like, okay, is that better than the UN? I'd say steaming diarrhea out of the ass of a pit bull is probably better than the UN. So the chances that it's better than the UN is like pretty much guaranteed. But I had a chance to go and dig into it and see what he's trying to do. He's already got several countries, a bunch of Middle Eastern countries that have already signed on to the international peace, whatever the hell it's called. One thing you can say about the guy is he definitely does a lot of really bold shit, and he's definitely not chilling on a lazy boy. He's an action-packed individual. It's just what he does action-wise is always interesting because he's an action-packed guy. So it's like action-packed. It's like, okay, we cut 465 treaties from the UN. I'm a big fan of that. Alex Jones announced that. I was like, oh shit, I'm in agreement with that, right? So it's like, now what? Okay, now what we're doing is this peace organization, whatever it is. Okay, what's that going to consist of? He's funding it. I forget how or whatever. And then there's all these Middle Eastern countries are paying to get onboarded onto this thing. He's going to be the chairman. So there's these conspiracies that this is his way of basically converting the government into like a private association so he can continue to have like presidential roles, right? But people are like, this is nuts. She's crazy. He's doing all this crazy shit. But it's like, from my perspective, I do crazy. That's literally my whole platform is me doing crazy shit legally and politically. So for me to say that Trump is doing crazy shit is like totally hypocritical. Like I am the poster child of crazy legal and political stunts. I don't call them stunts. I call them experiments, or experiments that have turned into technology. Technology is the term that I would use for experiments that have solidified, and now we just do it as a matter of day-to-day activities. It's not an experiment anymore. Experiments that have become technology. But with him, I think he's just bored. He's just old. He's done it all. He's fucked everybody that he wanted to fuck. He's done it all. He's done whatever he wants to do. He's made billions of dollars. He's done all this stuff. He's got Mar-a-Lago. He's the president. And I think sometimes he just does shit just to kind of amuse himself to some degree.
I feel like there's some credit. Like there's merit to that.
So you got this, a guy who's done it all and played it all and been everywhere. His idea of something he would need to do to create any sort of interest or excitement in his life is on the level of fuck 465 treaties with the UN, and then week later, fuck it, I'm going to start a peace, whatever the fuck it is, and I'm the chairman, and then a week later, fuck you, and there's like 12 countries that are given, it's just like, and he's sitting there like, oh, this is fun. Okay, this is exciting. I don't know. I don't know if there's more to it. I don't know. It's just kind of like, it's you don't see a lot of other presidents doing that kind of stuff. So I do find that kind of fascinating. You can't hate I just don't feel like you can hate the guy. I don't understand the Trump derangement syndrome, especially with the Trump derangement syndrome people. You ask them, okay, well, it's always the same question, even really basic level political communication. It's like the first question is, well, so you think that who was the person that he ran against in this last election? I don't even remember who it was. Who was the Democrat?
Kamala.
Yeah, so fuck. So it's like, all right, so you're telling me that would have been a better choice, and it's like that's a really good rebuttal, because it's like, fuck, like no, it's not at all. No, the answer is no, absolutely not. That is the answer. So, and they don't like that question because you can tell in their facial expressions and the way they react, the answer is no. but they try to like fucking, well, and it's like, they want to, so it's just funny. It's like the answer is no, and that's always their answer. But they don't say that. They contort.
The reason I don't like him is I think he's the best politician. He tries to like say I'm not a politician, and he's the best liar and the best manipulator. He's really fucking good at it. That's why I don't like him.
Yeah, I mean, it's just like I don't. Do I think there's something nefarious associated with him getting us out of the UN and opening up his own private group? I just don't. The chances, the percentage chances that he could create something, even has the capacity to create something that could be worse than the UN, is just, I'm not even sure it's possible.
Right.
So
no, there are if you were to break down individual actions, there are individual actions I agree with, but on the whole, I don't know. I also I see all of politics as theater. I don't.
Well, that's a fact. That's
Right.
just a fact.
Right.
I mean,
So I don't know that he's really on a different team than the Democrats. I think they go and they have their debates in front of the public, and then they go back behind the curtain and they're having lobster and champagne together. So
yeah. I don't. I mean, I don't. The question that I always ask myself, and the question that I'm always curious of, is what are these people really aware of? And most people that I talk to are, they know, and all this, and especially in the sovereignty space, they know all about U.S. citizen and negotiable instruments. But I'm telling you, bro, like from my own personal experiences, meeting so many people and hearing so many people talk and looking at so many things, I really don't think so. I really don't.
yeah.
Like, I really don't think anyone knows what a U.S. citizen is. I really don't think anyone knows what a Federal Reserve note is. Like, I'm not kidding. And
It's
that
a small percentage.
And that includes Trump. That includes Trump.
Yeah.
So I'm not saying that as a mean way towards Trump, because it literally is like literally everyone. Like literally everyone.
Yeah.
Like, everybody. Like, I've had reports of people who talk to presidents of small banks who don't know what a negotiable instrument is.
Right.
I am not kidding.
Yeah.
I mean, it is bad out here, guys. I mean, it is really bad.
Yeah. The wool was really pulled over our eyes for sure.
So I don't really go into the whole nefariousness and all this stuff and are they this and it's evil, and I just think everything we've seen since 1873 is just pure ignorance. Obviously, like, it is interesting how, like, all the pieces have kind of slowly morphed into this, like, prison system. Obviously, there is this, like, overarching shadow hand that has managed to somehow put all these pieces together into the system that it is today. But to say that each step was all calculated, I don't think that's true. I think they just are very resourceful at taking whatever major changes that has occurred and then finding a way to sort of piece all that together into a system that plugs in. I don't really think it's even. And then ignorance is their friend because chaos creates a cloud cover, and then they can operate
Right.
within that cloud cover. And I think as the ignorance goes away, the chaos goes away, and then the cloud cover goes away, and that's really when they're in trouble. And that's why I do what I do.
What do you think about this Epstein?
I think that's a lot more important and a lot more impactful and a lot more life-changing and a lot more society-changing than the World War III stuff.
Yeah.
I think the Epstein files is a humongous red landmark as a society, and I think it's extremely international, and I think it impacts the whole world. I think it impacts the United States more than the whole world, but I think the whole world is feeling the pain of the Epstein files. I think the whole world is feeling the pain of the Epstein files more than the amount of pain that could be created by a World War III. Besides, obviously, the countries involved in World War III, I think the countries that are actually involved in the World War III are actually going to be more affected by the World War III than the Epstein files, obviously. But beyond that, I think the Epstein files are more impactful than a World War III.
Yeah. Yeah. Why is nobody like why is nothing happening when all of this
I don't agree with a lot of that stuff. I don't think any of that stuff's true, and it's very like presenting the evidence to that is very simple. COVID. Nobody did anything during COVID, but then 2022, 2023, and everything, the media gets flushed down the toilet. Everyone's talking about sovereignty. Now here we are in 2026. No one's even going to pay taxes. Like it was like imagine like an old computer, okay, 2020, and it was like malfunctioning, processing, and then by about 2022, what had occurred had been processed. And then phase 2 of processed information is, what are we going to do about it? Now 2022 to 2023, 2022 to 2024, all this anti-vax and this stuff and slowly and all this stuff. Now we got black box warnings came out in 2024, 2025, whatever it was for the vaccines, all this stuff kind of, and then it went farther and farther. And it's just literally like since 2022, it's never stopped. It didn't happen overnight, but it's just been more and more. And now we're getting to the point now where no one wants to pay taxes this year. So, and they were already talking about that before the Epstein files. So the Epstein files just made that, I almost said 10 times, but it's really a lot worse than 10 times worse. It's like hundreds of times worse, really. It's saying 10 times worse is really an understatement. So I don't agree with the Epstein. I think the Epstein files is even harder for us to process than COVID. If COVID took us 2 years to process, the Epstein files could take even longer for us to process. Maybe. I was really depressed, dude, for like 4 weeks, bro. I was fucked up.
Do you think that anybody actually gets like jail time or any sort of punishment?
Other countries are starting to do it.
Okay.
Have you seen that?
No.
Sweden or something put together like a thing to like prosecute people in Sweden who have been connected with the Epstein files. I think, don't quote me on this, I want to say North Korea. I'm not sure on North Korea. I need to, but anyways, I just get kind of little glimpse and pictures of some of these things. I don't have a whole lot of interest in it, but slight interest in just kind of random pieces of information that come on my shit. Obviously, because of what I do, I get tons of political stuff. My entire feed is like half-naked girls, motorcycles, bulldogs, and political stuff. And most of it is political. So, and so, which is good. I like that mix. So all my favorite things, it's not, I have a slight interest in it, in world events, what's going on, politics, like my interest in it is slight enough to look at it.
Right.
Enough to want to see it on my feed. But in terms of the details and what's going on, do I want to stay on top of it? Absolutely not. Now, if something regarding the 14th Amendment citizenship stuff that's going to the Supreme Court popped up on my feed, oh, you bet your ass. I'm clearing my schedule. What's going on? What is this? Is there oral arguments being scheduled? When is it? What's the date? How do I access it? Is it available on the website? Is it a live feed? I would fly to Washington, D.C. if I had to see that shit. So, and there has been a lot of immigration talk and a lot of stuff. So like that stuff I follow up on,
Yeah.
ICE, been a lot of ICE conversations. There's been a lot of immigration There's a lot of pro-white movements that have popped up recently, some of which have reached out to me, which I'm totally fine with. I'd love to help. And they're talking about moratorium. So no immigration. There's a whole new movement for that now, where they're saying we actually need to do no immigration temporarily until we figure out what we're going to do with all the people who are already here who shouldn't be here. And then once we figure all that out, then we can reopen immigration. But you're not seeing that just in America. You're seeing that all over the world. You're seeing tons of countries closing their immigration doors or very heavily changing the way that they operate their immigration. You're seeing some countries open up immigration and they're literally just on a fast track of self-destruction, like Australia and the UK.
In the UK, I was just about to say England. Yeah.
So that's really sad. It's really sad to see that. It's really sad to see that. Really, really sad to see that. And obviously seeing that worries me about my country, because you have these white countries that are under a common law system, like Australia and UK, and we are a child of the UK, right? Essentially. So it's like I don't want to see my country follow suit with the country that's basically the closest country to us, which is the UK. We're basically a cell of the UK. Mitosis cell of the UK, essentially, right? So I that worries me. Obviously, I don't want to see what's going on there to happen here. That's terrifying. So keeps me motivated to do what I do, you know. But man, I'm telling you, I got 126,000 followers on the one Facebook account. I got 82,000 on the other. I got 89,000 on Instagram. I got 66,000 subscribers on my YouTube. I get millions and millions and millions and millions and millions of impressions and engagements on all my platforms combined every month. So, and I'm probably obviously one of the bigger people in the space, but there's lots of people with pretty big platforms. So this thing is, in just a couple, 2-3 years, I mean, 2 or 3 years ago, this space almost hardly even, it was super, super fringe.
Yeah.
It was like people talking about UFO abductions in 1992.
Yeah, no, it was.
That's basically the sovereignty space like 2 or 3 years ago. Now look at it.
Yeah. Yep.
So, you know, that's telling.
Yeah. And I think the work you're doing is, you know, people call you a purist, and I think that's accurate. But at the same time, you need that purist for everybody else to figure out what their route is. You know, how pure are we trying to be? How much is it a matter of being effective? You know, like making sure our time is being used to actually push this thing up the field. You always use the football field analogy, but yeah, what is the most effective way to move the football up the field? You know, and learning from mistakes that you're making and trying to make the whole process more efficient with each cycle.
Yeah, if you can't get anything through the courts, you know, it's like everyone's running around. The reason why I became a purist is because you can't get fucking anything in the courts. And that's why I became a purist. It's like, all right, you do all the stuff, you send your 3 letters. Oh, I don't do court, I do 3 letters. And it's like, what are you talking about? They take your letters and they wipe their ass while laughing, and they roll it up and they use it as a torch to light their fucking cigar while they're fucking their receptionist before they go home to their wife. They don't even read what's on it. They're all laughing, chortling like pigs over the idea that you sent them some trash that they're going to literally use to light their cigar and wipe their ass. So by the third, then I'm going to send a default, and then now they're defaulted, and now this. Okay. You're going to send that into the court? That's not going to work. It's like these people have never even, I don't know what they're living in this like delusionary playground. And then I go, okay, so you do that. Okay. You do the third. Okay. And then what do you do? Okay. We do the default. Okay, good. Now they take the default and they take their phone. They have an iPhone 17 and they put it on 4K ultra high definition video, and they bend over and they have shit all over their ass, and they take your document and they say, Mr. Alan, Barbarossi of 192 South Circle Court, blah, 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 blah. Here's your document. I just took a shit. I haven't wiped yet. And they bend over and they crown their asshole as they wipe, and then they wad it up and they go, fuck you, in 4K, and they send you the video. Now what are you going to do? I would fucking, and I literally talk like that. I literally give them these crazy descriptive videos, 4K, asshole wiping while they're banging their receptionist. And they're so confident. Then I'd fucking, and then I would do this. And then they wipe their ass with that one. And then they piss on it. And then they go online and they post a video of them pissing and shitting on it, and then they make fun of you and tell you to go fuck yourself and put your name and your address, and they say send piss-soaked pieces of paper to this address because this fucking lunatic is a retard. And then you start getting piss-soaked letters in the mail. Now what do you do? And then by the time I'm a very respectful, very gentle, very okay. Now that, and I'm always making these kind of silly examples of piss and shit and ass wiping, and they just get to the end and they just all this confidence and all this air and it just, and they just, you just don't know. And what do you mean I don't know? What are you referring to? Okay, we've gone here. Now what are you gonna do? Well, you just don't understand how hold on a second. You're getting off the beaten path. It's just work with me here. I'm trying to understand. Now what are you going to do? And I already know the answer. You're not going to do fuck you. That's the answer. You're not going to do a fucking thing. You're literally going to want to kill yourself. That's the ultimate product, right? That's the answer. But it's like, I can't just tell them that. Like, they're so delusional. I have to get them to realize that for themselves. So I just keep, what's the next step? What's the next step? And then we get to a certain point in the conversation and they go, way over here. And I go, whoa, what happened? We were here. What's the next thing right after that? Whoa, wait a second. You said you'd do this. You sent the three letters, and then you sent the default, and you got the affidavit. What's next? You just don't understand. You just don't get it. You just don't. And that's it. And because it's like I'm forcing them to realize they're fucking retarded and their shit's never going to go anywhere. And it's literally terrifies them. By the time they start to realize that, oh shit, I'm just basically at that point, I just fall off the end of the earth. There is nothing. There is no teeth. There is no nothing. There's no court procedure. There's no way to enforce any of this. Oh shit. Oh fuck. Oh shit. Oh no. Oh God. Oh God. Oh God. Oh God. That's the reaction. You know, I'm seeing a lot less of that though these days. A lot less of it. And when I say a lot, I mean a lot. I mean, like, I'd say that kind of stuff is probably down like 80% over the last year and a half.
That's good to hear. That means people, I take that as it means people are getting the confidence to actually take the enforcement step.
I think what's happening is the sovereignty space exploded, but it was in like its boy phase. And I think like it's still exploding, but I think we're moving into our man phase.
Yeah, maturing a little bit.
I think that's what it is. And to be totally honest, not to be egotistical, but I do believe that I'm a huge portion of why that's happening. Because I used to say a lot of boyish things, and here I am trying to correct and get everybody, away from the ROE onto the 8822B, away from this non-citizen national, which is an INA statutory class that I fucked up. Like, I'm trying to.
The fact that you can even admit that you fucked up is something that I highly recognize and highly appreciate.
Thank you. And I think that's to me, that's my definition of me going from a boy to a man. You had to be a boy to be a man, so I'm not like upset about it. I mean, I always say the same thing in all the shows. It's like, hey, at least I didn't charge you for any of this stuff. I mean, how are you going to be mad? Like, you fucking, okay, 1.0 and you ran out and did a bunch of shit and didn't really go anywhere. Okay, fine. But even if a small portion of it did, I mean, you didn't pay to be there. I mean, that's pretty, I mean, even if you felt better, even if you were like, felt less oppressed by the government, even if it was just an emotional effect, I mean, you made out good. You didn't cost you anything. I don't, to go see a feel-good movie costs $22. I mean, even if it's just a feel-good experience, didn't cost you anything. I mean, what's the problem?
Right.
But at this, I mean, I really don't have complainers. I have very, 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 very few complainers, because I've gone into chats before where there's a complainer and there's like 9,000 people jumping on him. Like, what the fuck? Shit's free, bro. Like, what the? You're complaining? It's free. And I by the time I get in there, the guy's already been beat to death by like 9 people. So I see a lot of that kind of stuff too. So it's sort of like, I have confidence in shifting away from the things that I got wrong, because I don't feel like I ever damaged anybody, because people never really got in trouble. It's not like any like real serious. I mean, the most serious thing that could ever happen to someone is they use the diplomatic plates and they get their car taken. Typically, they can get it back the same day or the next day. And then if you want to go one step worse than that, they get locked up for a handful of hours. Worst case is until the next day. But that's like unbelievably fucking rare. And that's by far the worst I've ever seen that can happen with it. Even 1.0. I mean, even if you go all the way back, the worst that could possibly happen is like the driving stuff. I mean, there's because people will say, the naysayers and all the fucking retards, they'll say, oh, this person tried to do that and they got foreclosed on. Yeah, but when you look into all that stuff, they were already well on their way to foreclosure. They were already 5 months past due, and they were looking for a solution. And a lot of times they genuinely couldn't pay it. They had no other. So to say that the cause and effect is at the 5-month point of not paying your mortgage, you started sending in negotiable instruments or whatever. And now they want to point and say, see, that's why they got foreclosed on. They lost their house, see, because they sent in and no, that's hit piece shit. That's media. That's how the media talks, right? That's not how it is. So the percentage of situations where someone raw dogged it right from the very beginning and did some sort of sovereignty action, and all the way through, that sovereignty action resulted in like disaster, like just doesn't even really exist. It's very, very, and some people will argue with me and they'll say, oh, this happened to me, and blah, blah, blah. And it's like, it's like, oh, I got beaten and then I got put in jail for a week and all this. And I used to get drugged by those people a little bit. Okay, what happened? Get me the footage, go get me the footage, go get me the body cam footage. And I've been thoroughly disabused of those people, because I get the body cam footage and they're like psychopathic in screaming, the windows up, fuck you, you fucking pig. You don't it's like, dude, like, Jesus Christ, you couldn't have. I mean, you might as well just pull a gun out at that. I mean, literally, like, that's a lot of the shit. And then I started thinking to myself, well, shit, does everyone who's getting in this much trouble act like this? And turns out, yeah, they do. And that's why I talk about that so much. The way you act and your tone of voice and your elocution, and kind of like, that's why I talk about that so much. Because I want to say I believe, but I think it's an objective fact that is the determining factor between, you get pulled over, worst case, your car's taken. Okay, worst case. You're super nice, you're super chill, everything. Worst case scenario, car's taken, you have to go and get it out of the bail yard. As far as I'm concerned, now you have a cause of action. Now you can sue the police station, you can also sue the tow yard. I've interviewed many, many people who have tow yards. I've interviewed or talked to tow guys, tow yards, all this kind of stuff, and they have taken what they consider sovereign citizen cars, and almost none of them that I've ever talked to has ever been sued by someone whose car they took. So you got to think from their perspective, there is no consequence to taking these cars.
Right.
And the police tell them to take the car. So it's like the bigger consequence would actually be to tell the police to go fuck themselves and not take the car. So what is the actual problem? The actual problem is we are not suing the tow yards. Joe Lustica sued the tow yard, and the tow yard brought him his car to his house.
I listened to that one. Yeah.
Within it was the same day or the next day, begging him to give him back the car. Well, at first he wanted $500, and then that turned into come get your car, and then that turned into okay, I'll bring it to you.
Yeah.
But still, right? So it's like, why don't we just have everyone in the country suing the police station and the tow yard?
Yeah. It's theft.
So it's like, okay, so you can sue the tow yard. They'll bring your car back to you, and then you still have a lawsuit. So now at that point, you had your car taken from you. It was an emotional experience. If you had children in the car, that's pretty rough. I won't deny it. But you get your car back the next day, and now you have a solid lawsuit that continues past that point. To me, that's a pretty good trade-off. Maybe not involving the kids. I'm not going to say that because I'm not going to evaluate that for somebody in their family, but minus the children. But what I would do, I'm resourceful. I would tell the kids that it's a game, and I would say, hey, we're going to go for a walk, and then, hey, I'm going to show you how to, this tow truck driver is a bad man, and you're Batman, and he's the Joker, and we're going to get the Joker. And I'd be like, and I would take the kid, and if he was old enough to understand, I'd be like, yeah, I would write the complaint with him, and we'd be going after the Joker. I don't know. I would figure out some way to, because I understand that the trauma associated with those kinds of experiences with the children is just like out of this world. That would be the only area that I feel we need to get more creative with. I think it should be something like transforming it into a comic book, and then we have the villain is the tow truck driver, and we're going to get the villain, and then now the kids, hey, daddy, what's going on with the complaint, and what's going on with, and you go with the kid to the thing, and you serve the documents, and with your cousin, and your cousin's got the meta glasses, and the kid's on his iPad, and he's watching with the oh shit, oh man, look at him, look, daddy, look, he just took the documents, I don't know, make up something that makes it that
not
transformed, that transforms the situation into something positive for the child, that gives the child power. Look, when you get older, you're gonna learn all. I mean, God, the kid's 8, 9, 10, 12. He's learning how to fucking sue someone. Like, fuck, he's already getting off on the right foot, man. You're being dad. You're not being dad of the year. You're being dad of the century, bro. You're being mom of the fucking century doing that shit. So I just don't. You're empowering. There's no higher level of empowerment. If you take the kid and get him a 4th degree black belt, you're empowering the child. But you're empowering the child with a personal, physical, confrontational confidence. Right. So if he gets in a personal physical altercation, he has confidence that he can best or defeat the person next to him. When you give a person legal confidence, I mean, that's incredible levels of empowerment. Everywhere you go, that can be applied every day. That can be applied everything you do, everywhere you go, with your banking relationships, with your business relationships. Even billionaires don't know jack shit about legal structure, about lawsuits. They don't know a fucking thing about it. So it's like, you want to talk about empowering your kid. People look at it as childhood trauma. I look at it as turning your fucking kid into a superhero. So I think it's perspective. Dad is the superhero, and he's going to teach the kid how to be a fucking superhero too. And I think that's that's the situation that needs to be created in that situation. Now you got the lawsuit, you got the superhero. Now it's turned into this whole family thing, and the whole family's involved, and the superheroes, and give the kid a cape. The kid's running around with a cape, super litigator, whatever. I don't know, something. That's fucking awesome. And that's what I'd like to see happening with this. And that removes this whole everyone's scared about traumatic stuff with their family stuff that I hear fairly often. That's a huge fear. We need to not fear anything. We need to become better at translating perceptions. That's what it is.
Yeah. Yeah, responding to negativity in a way that is empowering. And
It's like just translations. It's just translating everything. I mean, we're translating the law in English. It's basically what we're doing. We're just translators in a way, you know?
yeah.
Why can't we translate traffic stops? I mean, I don't see why we can't do it. You see?
Yeah. Yeah.
But these tow yards are not getting sued, I'm telling you. So if the bully's never gotten slapped upside the head, what's stopping them from, you know, we need to get some head slaps going. That's what we need to do. And from the very few people that I've seen do the head slaps, boy, they crumble, man. They crumble like a cookie. They crumble. I mean, I've never heard of one of these things going anywhere. They're crying over the phone, literally trying to get the car back. I mean, they are utterly terrified. I mean, they're from the reports I've gotten, they're at a higher level of terror than you were when you were in the traffic stop.
Yeah. I mean,
So
the consequences are higher, really.
So I don't know, like people say, oh, I had your plates and I got pulled over and all this stuff happened. I'm just like, okay, it's not really that big of a deal. I mean, we don't have people going to prison for years. We don't have any of that stuff really at all. I don't think I've ever heard of anybody really going to prison for any sort of.
And like you said, now you've got a case, really.
Yeah. And every time I've ever dug into people who did go in the slammer for a day or two, it was always because of like extreme behavior and disrespect. Extreme, very extreme. Very, very, very extreme. Like extreme. Like if a jury saw it, they'd be like, oh my God, this person needs to be like institutionalized. Like, I'm not kidding. Like that's the level of extreme, typically. And even those people only got a day. I mean, I literally would have done like more time in the prison cell than what the judges gave these people. Literally, I would have done more time. I would have said a week or 5 days or 10 days. And they only got like 1 or 2. So that's how bad we're talking.
One last thing, and it's only because I've heard you talk about philosophy with an type of admiration in your voice, and I know you usually talk about law and this stuff, but my degree is in philosophy, and so I just wanted to get maybe just like a quick summary on like your philosophy of life. I know it's hard to quickly summarize that, but like if you could boil it down to the essential aspect.
Well, I'm a Scientologist. You're aware of that, right?
Mm-hmm.
So with my religion, a lot of it's based off of like a lot of the issues in this lifetime probably stem from something from a previous lifetime, right? And so with that kind of mentality, like I do have that kind of mentality, obviously, that most of the issues that I'm experiencing and most of the issues that most people are experiencing are probably not of this life. I typically think of things that way, which is kind of interesting too, because obviously, like when I no longer have this body, I am sure I'll be back here, right? And that's another reason why I work so hard and I'm so concerned about everything, and I'm working so hard and so diligently all the time, because I look at it as if I don't fix this, then when I come back, it'll be 1984. It'll be a cyber dystopia prison. So I'm basically going to be born into a prison system, essentially. That's kind of the way I look at that. So, and then because of my religious experiences, I believe that almost everything revolves around the definitions of words. That's obvious. That's part of everything I do. But it's unique. It's like kind of a unique thinking that you don't typically see in society or in life. You don't people talking about definitions of words all the time in every area of everything. So that's kind of a unique thing. I think everyone's kind of trying to do their best. I think a very small percentage of the population is truly evil. I think 99 or even higher percentage of almost everything negative that we experience in an entire lifetime is typically just ignorance. I don't think that there is... I think that the presumption of evil and everything being so evil is... Obviously, the Epstein files have definitely rocked that boat, obviously, right? But still, even with the Epstein files, it's very, 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 very evil behavior. But it's only the list of all the people is very small, because to say that everyone who's ever ridden on his plane fucked kids, that's ridiculous. To say that every single person that's gone on his plane has done some horrific, terrible act that they should be hung for is also ridiculous. To presume that someone who's been on his plane multiple times, that would be definitely quite sus. If a guy's been on the plane one time and that was it, it's a bit, I'm just saying, like, the list of true evils of the people who were really engaging in true extreme evil is not that big, but it's by people that have such prominent classes, or they're this or they're that, and it's just like a lot more prevalent than people thought, and it's a big dump. So it's all the stuff that we typically don't see anything of, so it's relatively a lot. But I just don't think, like, I always tell people, like, I have even friends that, oh, everyone's evil, everything's evil, the whole government's evil. And it's like, okay, well, if that was true, we wouldn't even really have, like, a society, basically.
Right.
We wouldn't even be here. It'd be like, I don't know, Africa. It's a terrible thing to say, but it's like there'd be just huts, and it'd just be like endless clan warfare, and there'd be no technology, and, I don't know. I don't know. That's, and then I'm trying to think of what else. I don't know. That's the basics, I guess. I don't know.
Yeah, no, that's good. I think the one thing that I want to add is just the definitions of words. I would say core philosophy, or the theme, central theme of my philosophy, is a book called The Four Agreements. And agreements, like, having awareness of the agreements that we make is so incredibly important. Most people aren't even aware of all of their own beliefs and agreements that they've made. And getting granular like that with definitions, I think, is really important, because if you're not actually asking for you don't really even know what you're agreeing to half the time if you don't really drive at the definitions of the symbols that you're using.
Exactly. Or you presume they have the same meaning that they mean when they, that.
And the third agreement is don't make assumptions. And there you
Yeah.
go. I mean, if you're not asking questions, you're making assumptions.
Yeah.
So
no, it's 100%. I agree with you entirely. I mean, that's the basis of law, basically, in essence.
Yep.
Yep. I mean, that's why every single written anything in law always starts with the definition section.
Yep.
The lawyers want to pretend and just kind of roll over all that and play their stupid games. But if you look at the written text, it's all of the original technology is still there.
Yep. Well, this was awesome. It definitely went longer than I was planning, but the writ of certiorari, I didn't expect all that, but I appreciate it, because that was, especially for people who are newer to this material, at least, like my listeners, that's gonna be a good lesson there for them.
It's very advanced. I hope they can get it and enjoy listening to it. I hope they get something out of it. It's just to be forewarned, if we went through all that and you were just in a complete fucking daze, it's pretty pretty advanced to have that be your first foray into any of my platform. That's like entering the building at like the 42nd floor, really. That's, you know, so if you didn't really get that part so much, like, don't beat yourself up, because that's pretty fucking
Yeah.
But I hope it was, I mean, even if you got even just a couple little nuggets out of it or a little curiosity, that's plenty. I don't expect people to really have a
Well, even if it piques their interest enough to
Yeah.
go back and look at your, you know, groundwork.
Yeah,
so to speak.
even the slightest little positive element is enough for me on that, because that's not designed to have huge swaths of people understand that whole thing front to back, you know.
Yeah. Well, anything else you got to add, man?
That's it, brother.
Awesome time. Appreciate you.
Thank you.